Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today. We were going to go on at 10:15, but watching the court, they have decided to go early. So we are as well. So, thank you for joining us. Let me just check my mic. All right. Justice, thank you so much. Seems to be okay. All right. So without further ado, let's get to live court.
I have to first speak about burglary and false imprisonment. So,
we'll take a look at what I proposed. You're not objecting to the wording. Your issue is placement.
so that's it.
All right, let's just take a minute to take a look at it. I essentially adopted 99% of his suggested language.
And I'll say I used his document at the end of the day and just moved that around. That's it. I looked through the statutes. It seemed there has been less than of evidence. It seems like this is coming in, so the rest is appropriate.
Sure. when you all are ready, let me know. I can go back on the record. I reviewed it. I have some modifications.
Whenever you're ready.
It's on the record, Gabriella. All right, back on the record. Now, I'm going to ask you to enter this as court exhibit, whatever number it is, the first draft of the jury instructions.
Court exhibit is going to be court exhibit 2.
Can you also mark this as court exhibit 3, but you can't have it back? It's the second draft of the jury instructions, so that's going to be number 3. Yes. And then can you also mark this as court exhibit 4? This is defense's proposed jury instruction. I don't think it would be an issue, but I want marked and then this is court exhibit 5. That's the United States proposal. All right, go to page 8 of my second draft of the jury instructions. I just want to make sure you all have taken a look at it. I'm concerned with that big paragraph that has language in the negative. So if both sides have reviewed it, I reviewed it. I don't think there's any typos or any grammar issues.
I mean, it is off the standard.
It is. I added burglary and/or false imprisonment. That language is in there. Towards the end of the paragraph, it talks about retreating, being futile. Before that, it talks about herself and/or others and it would have increased her own danger to retreat. So I just want to make sure that wording is acceptable to the parties.
Yes, sir.
All right, let's move on to,
Yes, sir.
and Mr. Altala, I'm going to leave the placement of the burglary and false imprisonment definitions where they are, only because we have the wording of false imprisonment and burglary after that big paragraph.
I believe that's what I was suggesting.
all right.
It was Mr. Tomas's draft that was added a little farther down.
Okay. Burglary. My definition doesn't include the intent to commit a crime therein. I'm going to add in false imprisonment, which is what Mr. Tomas has.
Yes.
So let's move down to the definition of false imprisonment, to the definition of secretly, where I have victim in parentheses. Mr. Tomas, you have the defendant, right?
Yes.
Should it also have the minor children?
Yes.
So it should have defendant or minor children?
Yes.
Can it have defendant or minor child or minor children?
It can, or defendant or another. But defendant or minor children is fine.
Having minor children might be prejudicial. It should be another, the defendant or another.
Yeah, but who was in the house that she says she was afraid for? The kids, right?
They're already having an instruction at the very next sentence on confinement of a child under the age of 13. It's already addressing that, so it should just be the confinement of the defendant or another.
Over your objection, I'm going to have minor child or minor children.
Good.
And wherever you have the word Daisy Link, I just have defendant, just to keep it uniform, because that's what I have in other parts of the jury.
That's fine.
Okay. If there's no other suggestions, I'm going to move on to the other parts of the jury instructions.
I have no other suggestions for this portion.
All right, let's go to page 1. The cover sheet is standard. Page 2 is the statement of the charge. There's a typo there, crimes versus crime. I'll change that. introduction to homicide, justifiable homicide, excusable homicide, those are also standard instructions. Yes, no, on page 3. Just review it to make sure you don't have these other suggestions. All right, we can move on to page 4.
Page 4 of the city has that proposal.
Okay.
On line 2, where it says death is caused by the criminal act of, I believe it should say Daisy instead of defendant.
I'm just going to keep it wide. I'm just going to keep wherever it says Daisy Lee is now a defendant.
Well, we've already substituted victim for Pedro Jimenez, which should be defendant substituted for Daisy Lee.
Remember at the statement of the case on page 2, Daisy linked the defendant in this case. So they know from page 2 on, everywhere that it says defendant, it's Daisy Lee.
Understood. Just making my suggestion.
All right, let's move on to page 5, lesser included crime. Couple typos there. Right. There's a couple E's where they should be she's, the crimes should be crime, singular, and
Does it need to say the main crime since it's just one?
yes.
Okay.
So I'm going to change that. This is another suggestion, I'm going to move on to page 6, the definition of manslaughter. Okay, we'll move on to page 7, aggravation of second-degree murder or manslaughter by carrying and using a firearm. Should it be used instead of carried?
Be carried in more use.
I agree it should be both.
Mr. Tomas, all being carried or used?
That's fine.
I'll move on to page 8, we already went over.
Page 7 should we, I know it's giving a definition for the term firearm, but should those be in parentheses like that?
That's how the standard instruction is. I can remove it if you want.
Yeah, normally in the past I've removed that, you know.
Which part, starter gun or the,
Well, no, not the entire sentence, just the parent, like the brackets.
Okay.
So,
I'll remove those. The brackets, all 4 of them. Page 11, parental rights. As well as the use of transcripts of recordings.
regarding this page, Your Honor, the state did submit motion for Your Honor to take judicial notice. The state has done a diligent search trying to see if there were any type of court records of an injunction for protection from domestic violence or written pre-trial supervision order of no contact against that person. Looking at the clerk's website, there was no case active between Pedro Jimenez and Daisy Lee. So the state is requesting the court to take judicial notice of those lack documents and that it does not exist. Similarly to the parental rights instruction.
Judge, that's not appropriate. First of all, there wouldn't be any notice because those records are not public. As the dependency case was not public, there is an order which addresses the custody status, and that is the most recent order. That is in evidence.
Your Honor, injunction violations are public, and actual like arrest forms where there are pretrial services conditions are public as well too if there is a case against the two.
Aren't the pleadings closed? Whatever's in evidence is in evidence. Whatever I take judicial notice of, I'm taking judicial notice of, right?
Your Honor, we haven't read to the jury at any point in time this judicial notice regarding parental rights. We did suggest it towards the beginning. And we are introducing the actual court transcript as well too to the jury when they come back into it.
Well, there's a document from the dependency court limiting Mr. Jimenez's visitation of the children, right?
Yes.
Okay. And I already took judicial notice that there's no records in Miami-Dade County terminating the parental rights, right?
Yes, Your Honor.
So that's my point. At this stage, you want me to take judicial notice of other court actions.
That's correct.
So the pleadings are closed. Why should I do it at this stage?
Well, Your Honor, because it is essential for the actual justifiable use of deadly force jury instruction that's here. And if you go specifically to page, just one moment to go up. We go to page 9 and 10. It talks about the presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person against whom defensive force is used has the right to be in, or the lawful resident of the residence, such as an owner of lease or title holder, and meaning you have to have both of these exceptions. There is not an injunction for protection from domestic violence or pretrial supervision, order of no contact. Without that instruction here, Your Honor, and since those documents don't exist, the jury should be able to rely on Your Honor's judicial notice saying that that does not exist here to see that presumption of reasonable fear of imminent death does not apply here in this case.
So you're going on page 10, right?
Yes, I say 9 and 10 because it starts before where the rule is created and it's the exception.
So it's A, B, C, or D.
That's correct.
Okay. Are you planning on arguing that there's nothing in evidence regarding the injunction of protection from domestic violence?
I wasn't going to talk about that at all.
Okay. I'm having a hard time because the pleadings are closed. You want me to take judicial notice, essentially of a piece of evidence that no one has brought up until now. And the only issue that came up during trial was the limited supervision of the victim. And there's actually a piece of evidence, including testimony that corroborates that. So that's the issue I'm having now at this juncture. Plus A, B, C, D, there's an order between every single paragraph.
Well, if it's not being argued by the defense, then would there be a stipulation then to remove that portion regarding the presumption of fear?
Absolutely not. Why should I?
Let me give you an example. Vehicle is also discussed in the standard jury instructions. There's no evidence that there's any forcible entry of a vehicle, right? So there's language in here that's extra. It's just for the consideration of the jury.
And the jury should be able to consider this as well too, Your Honor. That's just a state's position.
And over your objection, I'm not going to take judicial notice at this stage of the proceedings. What about the language regarding the parental rights for the piece of document that's already in evidence?
Your Honor, the state agrees with that.
All right, defense.
Which part of the document?
Page 11.
No, that's fine.
Okay. And what about the use of transcripts of recordings?
Your Honor, I do believe you should insert Rule 2.2 here, which is instructions on edited recordings before the use of transcriptions and recordings.
Yeah, 2.2. Just reminding them that they listened to something that was edited?
Yes, Your Honor.
All right, what about use of transcripts and recordings?
That's appropriate.
Defense. I'm going to let them know that there is an item that is in evidence regarding the transcripts. All right, page 12.
It's like the standards.
It is the standard. All right, page 13. All right, tell me 6, 7, 8, 9, and 10, which ones you all want? 6.
Yes, Your Honor. 6 should be included.
Defense.
I'm not sure what has been introduced during this trial to justify this instruction.
Can you think of anything?
Your Honor, so PJ did testify during his testimony that he said he's here to get his mom out, and then he was asked, do you know where your mom is? And it was suggested jail. That is the other benefit here in order to get the witness to testify, and that did come out through his testimony.
You can still argue that without arguing.
But it should be something to rule that without the instruction, that's not something that the court can consider. And that's routinely said in closing arguments. Everything that's in this
I'm
packet.
going to leave 6N, but you can argue credibility, what he said, what he didn't say, and other things surrounding his testimony. I'll just leave 6N over the defense objection. 7, pressure or threat. Now this is where the PJ argument comes in. All right, there's no objection, I'm going to leave 7 in. 8, there was some attempts at impeachment, I'll leave 8 in. 9, there's no evidence of convictions of felonies or misdemeanors. 10, there's no evidence of any general reputation evidence.
Agreed.
15 is a blank page, I'll change that. Page 16, defendant statements.
That's the standard.
It's the standard. All right, rules for deliberation, that's also standard on page 17. Page 18, cautionary instruction is the standard. 19 is also the standard. Closing argument is standard, submitting case to the jury is standard.
Judge, just a suggestion, on page 19, the last paragraph, should it say the crime charge, since there's really only one?
To the crime charge.
Yeah.
Instead of each crime charge, to the crime charge.
Yes.
Okay, I'll change that. Okay, I'll be back. Just give me a few minutes. Estelle will bring me down the revised third draft. Thanks.
And Your Honor, I don't know if you want page 22 on a separate page.
I can figure out how to make it go up. I'll see what I can do. I told someone that
All right.
All right, so they were just briefly going over some jury instructions, really nothing too spectacular there. I'm waiting to hear the judge actually read these because we heard burglary, we heard false imprisonment, kidnapping, and as Barry, you were saying, maybe because after he was shot, he can't escape, I guess. I mean, do they always get false imprisonment and kidnapping for somebody who's been in his situation? I don't know. That's weird. So anyway, I'm waiting to hear from the the judge actually read those. Actually, we're a little bit behind. All right. Yeah, I think she told the jury to get here at 10:30. So they went on early. We weren't supposed to go on until right now, 10:15. But Judge surprised me. She went on about 20 minutes ago. So let's just review a little bit. I didn't really recap yesterday because there was just so much going on, right? We were dual streaming, plus everything was breaking loose here. They had a little PJ testify yesterday. That's Pedro Jr. Daisy, of course, testified, and then the rebuttal came back with Angel Wilson and Sergio Hermosillo, the two detectives. that was kind of nothing there. All right, let me go through her testimony. We can do that in 15 minutes or so. All right. All right, let's see, day 5. Yeah, and it started off with fireworks between the state and the judge. Those two parties are definitely, they're not going to be getting holiday cards at the end of the year, because they were just literally yelling at each other. And then the defense came in. I don't think he yelled until later. I think he didn't yell until later. Okay, so Daisy. So she's got 2 kids, Pedro and Mia. Pedro's 9, Mia's 11. They were 7 and 5 at the time. Pedro was about to turn 8. She said his birthday was August 7th. So then they talk about this 5 days prior to shooting. So Pedro, it was nonchalant at that point. It was on again, off again. He would come and go as he wanted. He lived at his mom's house 2 months prior to that incident. His driver's license, so he had 2 driver's licenses, and both of them showed that he had his mom's address. So to me, that shows he wasn't living there, right? I mean, your driver's license is supposed to show where you live. He had 2 of them, and neither one of them showed that he lived with Daisy. Now, here's the interesting thing. She kept saying, well, she was afraid. She didn't want to call law enforcement on him because she was afraid he was going to be deported. But yet he had a driver's license. So I don't know how that works. If you could be deported, are you allowed to have a driver's license? I'm totally, I don't want to bring politics into this for sure, but I'm just trying to figure that out. Is that a lie that she's telling, or is that truthful? So if you guys could answer me, and again, let's not get political about it, but can you be deported if you have a legal driver's license? Because to me, that means you're here, So how was she saying, oh, she was afraid he was going to be deported? Is that a lie, or is that the truth? Can you have a driver's license and still be deported? Those 2 things to me just do not. Those 2 things don't equate in my mind. So, all right, let's continue on. So March 2021 to 2022, and then 2022 to 2023. Pedro is not on the lease, so new owner bought it. That's why the new lease was drafted. Pedro did live with her, and he was on a lease at one point. She had to change the locks because he began to break in. So let's see. So the start of that. So he says, okay, let's. Mr. Tomas, her attorney, says, so let's start. Let's go from the start of the day, and then she kind of gets. She starts talking about day that he was shot, but then he's like, no, let's go back to 5 days before. Let's start over. So that day he took her dogs. She was home with guests, and this was around 9 or 10. So this is where her cousin David Perez comes in, and there's been some. They've mentioned his name a lot, where they're like, he's supposed to testify, then he says no, he's not going to testify, and Mr. Tomas, the defense, he wanted to have the court compel him to come and testify, but ultimately that did not work, or that didn't happen because David Perez did not testify. So anyway, David Perez, her cousin, he had 3 of his kids, came over. They were playing with Daisy's kids. They were just hanging out. And then Pedro came over unexpectedly, and then that's where Pedro busts in and says, oh, you're having an affair with this guy, you're sleeping with him, blah, blah, blah. She's like, no, it's my cousin. What are you talking about? This is my cousin. So Pedro pulled out a gun, charged her. This is where he hit her. So David and her wrestled the gun from Pedro. So she took it from him and she pointed it at him. But then she said, I guess their fingers were intertwined, so Pedro got the gun back. So how could you take a gun from somebody and yet your fingers are so entwined that he takes it back? Again, just not quite. It's not a huge discrepancy, but still a discrepancy. So let's see how many there are. That's at least 2. Can you get deported if you have a driver's license? And can you take a gun away from somebody even though your fingers are intertwined? So anyway, he got the gun back, pointed it at her again. She started to run to the front door when she heard the gun go off. She's not sure where Pedro aimed. Well, where did the bullet go? Did it go in your wall? Did it go in the ceiling, the floor? Where did he shoot? Where did the bullet go? It had to go somewhere. It's not like he shot into the couch. Like, where did the bullet go? So anyway, she's not sure where he aimed, so she ran to the door, fell down the steps. Pedro jumped over the ledge and pinned her arms down with his legs and started bludgeoning her with the pistol. David was shouting, and she was getting hit over and over again. Oh, here's where she used bludgeon, right? We were talking about that yesterday. The words that she uses. Started bludgeoning her. Who says that, right? I mean, in the common or the normal way of talking, you would just say, yeah, he started hitting me. He was beating the crap out of me. He kept hitting me, not bludgeoning. Great word, perfect word. I'm not saying not use it, but it just was just an interesting moment to be using the word bludgeon, my opinion. That doesn't mean anything. I'm just saying that I just found that interesting word to use at that point. So she tried to fight, screaming. Oh, and then this is when her son came over and said, get off, mom. And so Pedro stops and he ran off. So she and David took the kids to a hotel. She said she had forgotten her phone, turned the car back and headed back home. And that's when she said there was a bunch of police officers were there. So somebody must have called them. So then, this is when she talked to her sister. She sent the pictures. And here's the thing. Did she go to the hospital, right? Did she go to the hospital? I would have loved to have seen, we didn't see the pictures, but pictures were brought into evidence. Did she go to the hospital? Did she get this documented? And if she did, they should have called a hospital, a nurse, a doctor, whoever, staff member, anybody that could have been, oh yeah, she was here and she had this laceration. They said that you could see her skull. She was bleeding all over. I mean, go to the hospital, get this documented. All right. I think ultimately she said she didn't because, again, she didn't want him deported or something like that. All right. So David stayed, thought she might have a concussion. So she stayed up as long as she could. So ultimately she fell asleep around 5 or 6. She slept until 5 or 6 the next day, or that day, I should say. It's about 12 hours. Her son was screaming, thought she was dead. This is when Crystal comes over. That's her sister. And then Pedro says, oh, I love you. I'm sorry. Oh, here, why not call law enforcement? I couldn't. He would have been deported. Kids would have been taken away. See, that just doesn't make sense, right? This doesn't make sense. If he has a driver's license, why would he be deported? And then why would the kids be taken away? You have rights to them. Why would the kids be taken away if he was deported? Yeah, you know what I'm saying? Like her stories, these inconsistencies just don't make sense. So, and he did get arrested once because he is in what do you call it? There's a picture of him here. Richard found this picture of him. So that's his mugshot. So he was arrested at some point. So now she's afraid that he would be arrested again and be deported, and then the kids would be taken away. I don't understand that. I just don't understand that. So she says she loved him. I'm sure she did and does or did, whatever. So she took him back home and meant she forgave him. So let's see, she said she did whatever. They went to Dave & Buster's. He bought her a new ring. They had a good time. Okay, so then June 25th, he was going to leave the next day. So he was at his mom. She picked him up around 1:30 or 2. This is when her mom was there as well. Her mom is Josephina. She wanted him to get arrested, but Daisy wouldn't allow that. So Pedro was going to leave for work, and then she wouldn't see him. So he goes. He's an interstate truck driver. So he leaves for like months at a time. 2 months, she says, up to 2 months at a time. So she said she saw him leave in a white van with Kevin Bonilla. We heard from Kevin, remember? I think he was the first. He was the first or second. Kevin Bonilla. Yeah, he was the first witness, actually. So Pedro told her to pick her up later because a tree fell on his car on a base in Orlando. That's a real random story or line. He didn't have a phone either. So later, she says later meant 3 or 4 a.m. So she's like, no way was I going to wait that long. So she went to go pick him up at 10 or 11. She brought him back home. While driving back, he said, stop, let's get some beer. So he had a phone, but he disconnected it.
Where we made edits. Acceptable to you all. I did have to set fire off 9 copies to the jury. This is all going to be a court exhibit, is number 3.
I apologize, I'm still going through the case.
I'm sorry, whatever court exhibit needs to be.
6.
I'm going to give you back these court exhibits.
Do you mind opening some stuff around? Thank you. Page 9, just for reading it, access is confinement of a child by sentence. It jumps into deciding whether the defendant is justified. I mean, visually, I would think that there needs to be an extra space between the two. It kind of looks like a continuation of the false imprisonment. I don't want there to be any confusion, but
Defense on page 9. An extra space.
I mean, an extra space, or just start that at the next page?
yeah, either or.
All right, I'll do an extra space. Is that all?
I'm almost done, but that was it on that page. and as well as the verdict form.
All right, defense.
No issues, Judge. I don't have the verdict form.
I emailed it last night.
Oh.
There's one little typo. I'm gonna do it in 2 pages. You can have mine. Well, then, we'll start all over. Okay, I'll make those changes. I'll come back. I'll come back with probably 15 copies. And feel free to call Chambers if you all see anything else you want me to change. I'll be back.
All right.
So the judge, excuse me, judge is making copies. Yep, making copies. Yeah, her baby was born, seems like June 2024, and I think it's with Joan, I believe that's how he says his name. Let me do this. I think it's with the father's mother, I think. I think that's what we figured out. So, excuse me. All right, so judge is off making copies, and yeah, she just has like just these inconsistencies. Let's see, let's keep going on. Oh, I asked yesterday how much do you believe Daisy? So 100% believable. 9% of you thought that. 75% she's doing well. 17% thought that. 50% I'm seeing holes. 50% thought that. 0% no credibility whatsoever. 24%. So yeah, I'm seeing holes as well. So, but I think like we were just talking in chat, it only takes one juror, and there may be some sympathy for her that Pedro was not a good guy, right? She said she loved him, sure, but doesn't sound like he was a nice guy. Doesn't sound like she was too nice to him either. She hit him with a frying pan. That didn't come out as evidence, but that they were talking about that when the jury wasn't around. So she apparently hit him with a frying pan. After he hit her, she apparently broke his. It was a window of his truck. I don't know if that was his rearview window, mirror, or if it was the window into his truck. I'm not quite sure. I didn't catch that. But again, toxic relationship. How many times do we talk about these toxic relationships? And she was this close to getting away. She was that close to getting away from him. This happened at like 3:15 in the morning. He was going to leave, go on he's a trucker, so he would have been gone. And she was that close to, maybe another 6 hours she would have been out of there, So, hold on a sec. Let's see. All right, let's get to cross. All right, Pedro has committed DV against you, and you him. She says yes. She changed the locks on him. He never had a key. So your mom testified to Pedro choking you. She says yes. She never called law enforcement. Kids and grandkids were home. She could have taken them, but she didn't. Why did your mom leave her grandchildren around such a dangerous man? She's like, I don't know. 4 pieces of paper were stopping you. Yeah, you guys were saying that she had to have supervised. Pedro had to have supervised visitation. And it was his mom that had to be there, but mom was in Georgia because Pedro's dad was abusive to Pedro's mom. So there seems to be like a history there. Maybe that's where he gets it from. If dad is abusing mom, he's going to abuse his wife, his spouse, his significant other. You know how that works. So let's see what else. She says he wasn't a bad guy. He didn't have a knife or a firearm. She was the only one that had that. He was never armed. She didn't want to keep getting hit. like things like that. Maybe she'll find some sympathy, with the juror. Maybe they'll be like, yeah, you know what, he did. She was afraid he was going to run. Well, here, hold on. Let me go through this. Let me go through what she's saying. What happened the day of, or as it happened. Okay. So the kids were locked in a room. Mom. Okay, hold on. Her purse is missing. So he comes back 3 times, right? And he's hysterical crying. He said, "You ruined the entire family." We heard that on the ring camera. Remember, we listened to that and we heard him say, like, we thought it was like, something like, "Dude, I gave you everything." So she's saying, yeah, he's saying that, "I ruined the whole family." He's hysterically crying. She's scared and knows he's been using. Don't forget, she said he bought 6 bags of the white stuff when he was at his buddy's house. She said his demeanor is escalating. Then she says her purse is missing, which has her phone and her credit card and some jewelry. So she goes to the alley. She assumed Pedro left, so she put the gun on the china cabinet. She goes out to look for her purse. He jumps out and throws her on the floor. Again, somebody who says floor instead of ground. Mom is screaming. She's going to call 911, so he takes off again. So mom says, "I'm tired. I'm leaving." It's around 1:30 or 2. Kids were locked in the room. They were sleeping. He's yelling. She was yelling at him to leave and not come back. So she goes to the porch. She's smoking a cigarette with the firearm. Pedro comes back and saying she was sleeping with another guy. She said she got tired of lying to him, so she told him, "Yeah, I am sleeping with another guy." Told him she was sorry, and he charges her, calls her, all kinds of names. "I gave you everything." Maybe that's where we hear. That's when we hear it on that ring. I think he's like, "Dude, I gave you everything," or "Yeah, I gave you everything." I definitely heard, if not that, then something very close to that. So he grabs her hair, throws her on the floor again. So her wounds rip open. Again, we would have seen that. Why didn't the police photograph that? So she grabbed the firearm from the slab, told him to leave, told her he was going to lock her out, and she was, "I don't care if you, take me out," he yells. And we heard that. We heard that on the ring camera. He runs to the house. He's going to barricade himself at first, but then he ran off in a different direction. She said it didn't appear to be injured. Here, let's play that while we have some time. I don't know how much time we have, but guess what? We can always fast forward during a break. Let me play that again while we're waiting. Here, hold on. Let me play this again. All right, hold on. Oops, hold on. So it's that's when he's like, I want to die. That's when he's yelling, I want to die, and he's like, do everything, Definitely heard that, I'll do everything or something like that. But then, yeah, she walks back. It's not like I hit a major artery or anything, So what did she say? She says, hold on a sec. You'll be fine. It's not like I hit a major artery. That's not what I said. So she says, you'll be fine. It's not like I hit a major artery. She says, it's not what I said. I don't know. Kind of sounded like she said, it's not quoted right. Do you want to go to the hospital? I could have hit an artery. It wasn't to mock him. So she says, I could have hit. Do you want to go to the hospital? I could have hit an artery. I thought it says, it's not like I hit a major artery. She's saying I could have hit a major artery. So that's what she's saying she said. I think she says it's not like you hit a major artery. That's what I hear, but she's saying, do you want to go to the hospital? I could have hit an artery. I thought she says it's not like I hit a major artery, but I thought I hit a major artery. You will be fine. I thought she said it's not like I hit a major artery. Well, here, let's go back. Let me hear it again. Maybe she does say, I thought you hit a major artery, but I don't know why she would be like that. But yeah, I could have hit a major artery. Do you want to go to the hospital? She says, you'll be fine. She's saying, do you want to go to the hospital? I could have hit an artery. There's definitely something about major artery in there. Anyway, all right. So that's that. Donna says, I doubt I hit a major artery. That's kind of what I hear too. That's what I thought I hit a major artery. But why would she be so nonchalant? You'll be fine. I thought I hit a major artery. Why would you, that's really callous if she said, I thought I hit a major artery. And then you see him run, and here we thought, he'd have to be running with his leg up, right? The whole thing. Remember we did this whole thing? Are they here? Where are they? Where are my, oh yeah, here. So he'd have to be running like that in order to be shot through the foot, then into the thigh. But you saw him running away. He was not running like that. He was just kind of like, just kind of shuffling to get away. So then that kind of throws a wet blanket on that theory that he was running like that. I don't think he was running like that.
The bathroom was 90 on. Can someone help me with that static noise?
We're trying to figure that out.
Did someone move that podium? Or at least, which
It's not this one. It's our one you stepped out randomly.
Alright, never realized I can't figure it out. I'm gonna give myself another quarter. I'm gonna give myself another quarter if you can't figure this out in the next 2 minutes. It's fine, starting at 9 a.m. this morning, now something's going on. Do me a favor. Ask across the hall, and do one of the quarters.
Shoot two, I won't lie, she's off the bench.
Let's check the two across the hall.
It's channel 8, but I don't know the numbers, like which mic.
Is it channel 8? This one. This is why
It's the wire. Yeah, it's the wire on this one.
Okay, move it. Move it around.
that one? I don't think so. It says the courtroom TV is muted. Not that I'm aware of. No, it's muted. Six at the top of it too. So this microphone, does it have a different podium? That's not me.
Alright, folks, we're gonna move to 2-2. Sorry about that. Huh? Take your time.
It just stopped.
Stop it. I've gone,
It's been off for a little bit.
Quiet.
So they're moving across the hall. They're going to move to another courtroom. How's that going to impact us?
Should we stay?
I think it's fine. I don't hear anything in the, I haven't, are you moving something?
Can't touch it.
There's like a little bit of static, but it's not like
How do I know it's not gonna stop?
that. I'm not sure. I don't know if it'll like start up again. It seems to be it's something with that wire. He was saying that it looks a little bit like exposed.
Okay, I'm just gonna go to 2-2, folks. Sorry about that.
Okay. Pretty sure. Yes, excuse me.
Oh, no, this way, this way, this way. Thank you.
The courtroom. Is that arch? Yeah, it's not wrong. That's theirs, right? Yeah. So then they have to bring one.
Gotcha.
call Lewis.
Our data visual TV.
Where's Lewis? The video and audio.
As long as it's there. I'm not I don't have to call anybody. They have to call. Yes, me.
All right, not quite sure how that's going to affect us. All right, so the judge was complaining about the podium was giving off static. So if we can't fix it in a minute or two, we'll have to move across the hall. And then the clerk said, well, it's giving off a little bit of static. There's a wire that's a little bit exposed. So they have a wire that's a little bit exposed. Hey, Dwayne, good to see you. Woke, good to see you as well. I see you came in. This is really, really interesting. I really don't know how this is going to affect us. Karina, did the static just start? Apparently. I mean, the acoustics have been, just really bad the whole trial because it seems like they really only have like one mic at the podium that's picking up everybody. So the admin, the court admin, is like right next to the podium. So you hear that person, whoever's there, shuffling papers, stapling, coughing. You hear them like I'm talking, and then the judge is like way over there, so you barely hear her. So it seems like they only have one mic at the podium. And then you've got these ceilings that are like 20 feet tall, so it's like cathedral ceilings. Well, this is going to be very interesting. This is going to be very interesting. I hope so. They should be able to. They will probably move the camera feed. They should be able to, Rich. They should be able to. It shouldn't be too big of a deal. But will the judge wait? Okay, boom, and there the feed goes down. So that's them unplugging. This is really funny. This is really funny. Okay, there's the live view. So all right, so you're gonna see them connect back up. All right. I would assume that's them disconnecting, and then that's really fast to reconnect. So that's the live view. Yeah, Kimbers, remember you said you saw somebody with a shirt that said live view. Live view is just like the hardware, and it's literally physically a piece of hardware, and then you get these modems, and then you plug into the court feed, and then the modems kick it out, and then you can tap into that. So that's what live view is. Sharon, oh boy, something is bound to go sideways. I'm telling you, this trial has just been nothing but crazy. That's all I can say. It's just been crazy. Hey, Red Snap, good to see you. Thank you for coming in and joining us. Yeah, yep. Kimbers, that's what you saw exactly. Yeah, so that's not a it's not a station or a channel or anything like that, or anybody. It's a company that owns this equipment. Scott has it. RA has it, and he let us use it when we went to Sarah Boone. So it's cloud-based, IP-bonded live video solutions for contribution, production, and distribution. So you literally, you could go to a sporting event. You see this, any kind of event. I used it for Sarah Boone. I went there and I plugged in. It's these BNCs, and you plug into the feed. Like there's a pool camera. There's one camera, two cameras, three cameras, whatever, but it's a pool camera, and then they pipe that out to the media, and then if you have a live view, if you have the right equipment, you can plug into the courtroom's board, if you will, and then that goes out. Then you use the live view and modems, and then that streams out, and then that gets picked up, and then that's how we were streaming Sarah Boone. So kind of the same situation here. It seems like live views are pretty much what everybody uses. I don't know if there's any other. It's trusted by law enforcement, defense, critical infrastructure, and emergency services. LiveView delivers high-quality, reliable real-time videos from drones, vehicles, and body cams. I didn't know that. Interesting. Yeah, so instead of those big satellite, trucks, you see the trucks with the big satellite dishes, this is basically has kind of taken over the satellite trucks. I mean, those things still exist, I guess, but this has kind of taken over that. Hey, Tosh, good to see you. Good morning to you. Mrs. Baba Yaga. Maybe I missed it, but did they ever do anything on contempt of the witnesses? No, they haven't yet. I think they were going to wait for the trial to end. From what I understand and heard, I believe they said they were going to wait for the trial to end, and it was going to be Crystal. It was going to be Crystal Barreto, the sister, because she was the one that was apparently on her phone watching Law and Crime, which is a crime because she should have been watching us. She was watching Law and Crime. Kathy, yeah, it is one for the books. We'll be talking about this one in 10 years for sure. Yeah, this is so crazy. Gretchen, this trial is brought to you by... Yep, totally Benny Hill. Never a dull moment, Agent. Agreed. Never a dull moment. It's too funny. Yes, Dwayne. Kimbers, thank you for taking us to that beautiful memorial mural for Julian yesterday. It was very touching. I teared up along with Chris when you placed the 3 green balloons. Yeah, that was sweet. That was sweet. Honestly, it's like one of Shakespeare's comedy of errors, for sure. For sure. No problem, Mrs. Baba Yaga. Hey, Chris. Hello to you. Just want to say good morning. Probably go back to lurking till you wake up more. No problem. Kimbers, you 3 balloons. You did it for all of us. And a lot for me to do that for all of us. 3 green balloons for forever 3 years old. Aw, that's sweet. Let's see. John says, I think state will file perjury and witness tampering charges later, especially if Daisy is acquitted. Absolutely. CCG TV. That's why she got caught, because she wasn't watching us. Exactly. Exactly. Brad, that's the same physical sign. See the imperfection around the L as before. So if the feed is moving to a different courtroom, we're currently not getting the new courtroom, I assume. If this is the old courtroom, then we're not getting the new one. Let me check around, see what we got going on. All right. Yeah, not a lot of people are covering this. Let's see here. Yeah, it is not. This is where we are. This is where we are. I would assume, though, Brad, I think they have that in all the courtrooms, but you're right about that imperfection ding there above the L. That is the old one. Plus, when they killed the live view and they set it back up again, that was too quick to run across and get set up again. So this is as good as we're going to get for now. Nobody else has it. I just checked some other channels and they don't have it yet either. So. We'll keep watching these other channels, just in case. Let's see.
All right, Ms. Lee. Regarding the jury instructions, I've gone over it with the lawyers, we've seen the back and forth. I just want to make sure that you've had an opportunity to confer with Mr. Tomas about the proposed jury instructions.
I have, Judge.
You're in agreement?
I am, Judge.
Okay. Each side still wants about an hour for closings.
Yes.
Let's just keep in mind, I'd like to feed this jury at 1 o'clock. I know the delays were not our fault, but you want an hour too, Mr. Tomas?
As same amount of time as the state.
That's fine. All right, Mary Lise, you'll keep track. Does the state have a specific request as a warning from the clerk? Do you want to record for rebuttal?
For me, Judge, I'd ask for a 10-minute warning, 5-minute warning, and 1-minute warning.
All right, Mary Lise. Yeah.
15
15 into your split.
first close.
Right, I know. So you're gonna tell the state when they're at that 15-minute mark, and then Mr. Tomas wants 10, 5, and 1. Countdown. 10, 5, and 1.
Your Honor, still not complete. We did discuss it yesterday before we left, that Your Honor would put up the jury, talk about the actual transcript itself. And just as the statement mentioned earlier today, you did notice regarding the parental rights. It's in the jury chair, so it's about those never read. So we reflect that it be read on how the piece of evidence.
I got it.
You don't have an objection to that, Mr. Tomas?
No.
Let me go off record. All right, camera folks. 2 more minutes.
Yeah, when the trial first started, we had this angle. This is the courtroom camera, and that guy in the white and the guy in the orange shirt, he's got the badge. They're setting up another camera. That's the pool feed. So this is what happened when the trial first started. We had this angle, and this is the courtroom camera, and then that gentleman with the blue shirt, orange, he's got the badge. That's him setting up another camera. So they're going to probably switch over to him, which will be kicking back towards us. That'll be a better, yeah, see they're setting up. So you see that guy in the orange shirt, blue top, there's the camera behind him. They got the guy in the black and white plaid. That's them setting up. So eventually this happened to us the first day. I think the first couple witnesses was this angle. This is the camera. This is the courtroom camera. And then those guys setting up that camera, kind of where our logo is, that's the camera that's going to be shooting back towards us. So that camera will be a different angle, obviously, a better camera. This is just a courtroom camera. This is like Zoom almost. This is basically just a courtroom camera. And then you see that, look, if you see our logo, you see them working frantically trying to, because they're on the clock. They're like, come on. Everybody's waiting. Let's go. If that was me, I'd be like, oh, I'd be sweating. I'd be like, quick, come on. Come on. It's like Caddyshack. Well, we're waiting. You know, come on, man. Everybody's waiting for you. Get that camera set up. Talk about pressure, right? Oh, Courtney Clenny's been delayed. It won't be December 1st. That stinks. All right. I mean, theoretically, they could start because I think the first 2 or 3 witnesses were this angle, and then they switched it. So they could theoretically, we won't see the witness, but they could theoretically use this. They did it before. So they could theoretically start. I should fly a helicopter to Miami and steal a camera. Oh, I'm sure they know what they're doing. It's just that pressure is on. Is that a juror chair in the upper right? Yes. Yeah. Yep. John, that's where the jury sits. Yep, right where the bailiff just walked by, the very far upper right. Yep, that's where the jury sits. That is where the jury sits. So when they get this camera set up, get this camera angle set up, they're going to be coming back towards us. So where our logo is basically shooting back towards where we're sitting right now. So Raul is going to start on the 17th. Yeah, we saw he had like a 3-minute hearing. He needs counsel. We did see that. He represented himself yesterday, and he says he needs to find, because financially he can't afford. He said they spent a lot of money with Kevin Smith in his first defense. So, oh, you're welcome, Red Snap. No problem. Yeah, everybody's trying to help. You see them? There's a bunch of people there now in the upper right. They're trying to get this sorted out. There's some people. They're sitting. Okay, they're sitting. So the camera operators are over there. It shouldn't be. Oh, and we froze. Oh no! And now they froze. Oh, okay. Yeah, this is basically. Oh, he's going to turn that. All right, this guy's going to turn this camera off, or is he? No, he's moving it. Oh, because they were saying, yeah, you could see the jury. See, John? They probably said you can see the jury, so they moved it. They had to move, Daisy, they had to move courtrooms because there was static at a podium, so they had to move to a different courtroom. We are too, Kelsey. Yeah, I guess it was financial. Raul said it was it was just too financial, too costly. Mary Fitz, I alleviate hosting by Squeegee of Justice. Does Pantsuit Lawyer have us on her laptop? I don't know. I can't zoom in. That'd be fun to zoom in. Or the who's this woman with the long hair, with the headphones on, sitting with the two? She looks like a streamer. I wonder what she's doing. Oh, and there's a photographer. See the guy with the hoodie, the jacket, right? With the cameras. He's got some big lenses. That dude's got some big lenses. How many AV techs does it take to get this set up? See, now this is great. This is a really cool thing, you guys. This is behind the scenes. This is some really cool behind the scenes stuff. You don't get to see this in real time. You don't get to see this. Here's the technicians, the camera operators, the AV, which is audio visual, all scrambling, trying to run cords, get things set up. I'm totally digging this. Independent trial channel. It's independent trial coverage channels like this one. Let's see. Oh, okay. You're done with, yeah. I hear you. Yeah, well, that's what happens, you know. That's what happens. I'm glad that you found us. Thank you. Thank you for joining us. We can see the state's laptop screen. Yep. Oh, did she just look up at us? Oh no, she's laughing. Okay. Yep, we are streaming you. Yeah, so we see the still photographer. He's sitting there, older gentleman with the hoodie and the cameras, and then we see these other folks trying to run cords. They got to get power. They got to connect to the connect their camera, make sure they have audio, connect their live view. Then they have to connect to the buildings out. So they got to connect to the buildings. These poor guys. I feel for you. I feel for you, man. Because they know they know the world is watching them right now. Not only is this courtroom watching them, but they're watching. They're being watched by us, and I know Scott's streaming. Of course, Court TV, Law and Crime, they're all streaming this, so they probably have about, I don't know, 5, 6, 7,000 people watching them right now. Well, let's see who's watching. Who's watching Law and Crime and Court TV? Let's see. All right, Law and Crime. You've got about 1,000 people watching on Law and Crime. We have 200 people, so it's about 1,200 people. Scott has 1,600, so you're about 2,600 people watching. And then you've got 500 people watching on Court TV. So you got about 2,000. About 2,000 people on just those 4 channels. I don't know who else is streaming, but just those 4 channels, you have about 2,000 people watching. So it's pretty funny. Thank you, Dwayne. You ran away and found us. Been so happy since. We're happy you found us. There's no drama and attacking in here. Nor should there be. And if there is, we will not stand for that. Gretchen Wright, 3,000 people and Daisy's sister. Exactly. Sakari, the pressure's on. Come on. What's the Jeopardy? Do, 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 do. Oh, wait. Maybe, okay. All right. Courtroom TV. They should be switching over now. I'm hoping that they're switching the angle. We should, fingers crossed, we should switch angles. So if they got all their cords plugged in properly, if they got their cords plugged in properly, we should be switching. Let's see if they, and there's no way to test. That's what stinks. There's no way you're testing on the fly. Cue the Jaws music. Nice. Norma, thank you. The best channel. What is the next trial? Not sure, JMS. We kind of fly by the seat of our pants sometimes. Sometimes we know what's coming up. Other times we're like, hey, Monday comes around and there's a trial and we have to scramble to cover it. All right. Yeah, they're testing on the fly. Oh my God. They're going to take, they want to feed
We have the list of the jury verdicts once. The alternates. Not going to need it for a couple hours, but. And then you'll excuse them. You'll just read out those 3 names.
All right, they're still sorting it out here. Clearly they're trying to switch cameras. Yeah, this is my cup of tea. They're trying to switch cameras. Because we already had the one angle and they were setting up across the room, so they're trying to switch cameras. Camera feeds, I should say. So they're doing this all on the fly. This is really a great behind the scenes look, you guys. This is what we never ever see, because theoretically you should be doing this before trial starts, or before the day starts. Make sure everything's set up. You check your mics. We've been in courtrooms, Bianca Ellis, they check their mics. We heard them do mic checks like a half hour before. So usually all of this is done before the day starts. So we are getting a look behind the curtain. We're having a fire drill, right? And Brat's cup of tea of his can of Mountain Dew. Yeah, the Jeopardy theme song. That's funny. All right, so we just wait till they get it sorted out. Really not much more we can do.
All right, for the jurors.
Well, at least we get audio. All right, at least we get audio. We'll see when the video kicks in.
Hi, folks. Good morning.
On jurors accounting for.
Thank you. All 9 jurors are accounted for. We can be seated. Lawyers are present as well as asleep. I'm sorry for the delay. So the delay was due in part to audio issues in my courtroom, which happened not even half an hour ago. We had to move. I thank my colleague for letting me use her courtroom. In a minute, Lisette is going to hand you jury instructions because both sides have rested. You're going to read along with me. I have to read it into the record. It's easier, I think, if you absorb the information as you follow along with me. A copy of the jury instructions will be sent back to you as you deliberate, so you don't have to memorize anything in these instructions, but please pay close attention to them. And I'll tell you which page number I'm on as we read along together. There's 2 instructions that I need to read to you as part of the evidence. Number 1 has to do with parental rights. It's also part of this instructions. The court has taken judicial notice that there are no records in Miami-Dade County terminating the parental rights of Pedro Jimenez. Also an instruction on the use of transcripts. Someone had asked about transcripts. There is a copy of transcripts that will be available to you, but it is an aid to what you view in the evidence being the statement of Ms. Link that was already introduced into evidence. So you heard a recording and you will be furnished transcripts of the recording. The recording is the evidence. The transcripts are provided to you only as a guide to help you follow. And as you listen to the recording, the transcripts are not evidence of what was actually said or who said it. If you notice any difference between that and what you hear on the recording and what you read in the transcripts, you must rely on what you hear and not on what you read. All right, so I'm going to read a paragraph and then we're going to start with the jury instructions, and then the lawyers will have an opportunity to make their closing arguments. Both the state and the defense have now rested. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening and a rebuttal argument after the defendant has spoken. All right, I'm on cover page of the instructions. Members of the jury, I thank you for your attention during this trial. You have now heard all the evidence in the case. In a few minutes, the lawyers will present their final arguments. First, it is my duty to instruct you on the rules of law that you must follow and apply to arrive at a proper verdict. I'm on page 2. Daisy Link, the defendant in this case, has been accused of the crime of second-degree murder with a firearm. Introduction to homicide on page 3. The defendant is accused of the crime charged in count 1 of the information of 1 count of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable homicide or that was committed by a justifiable use of deadly force is lawful. If you find Pedro Jimenez was killed by the defendant, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder or manslaughter, or whether the killing was excusable homicide or resulted from the justifiable use of deadly force. Justifiable homicide. The use of deadly force to kill a human being is justifiable homicide and therefore lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in or upon any dwelling house in which the defendant was at the time of the killing. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means harm that is more than slight, trivial, minor, or moderate. Excusable homicide. The killing of a human being is excusable homicide and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune and doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. I now instruct you on the circumstances that must be proved before the defendant may be found guilty of second-degree murder or any lesser included crime. Second-degree murder. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. Number 1, Pedro Jimenez is dead. 2, the death was caused by the criminal act of the defendant. 3, there was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Lesser included crimes. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of second-degree murder with firearm is manslaughter. Page 6, the definition of manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Number 1, Pedro Jimenez is dead. 2, the defendant intentionally committed an act or series of acts that caused the death of Pedro Jimenez, or the death of Pedro Jimenez was caused by the culpable negligence of the defendant. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, which caused the death. I will now define for you culpable negligence. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to do harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. For negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or grossly careless disregard for the safety and welfare of the public. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. 7, page 7, aggravation of second-degree murder or manslaughter by carrying or using a firearm. If you find that the defendant committed second-degree murder or the lesser included offense of manslaughter, and you find beyond a reasonable doubt that during the commission of the crime she personally carried or used the firearm, you should find her guilty of second-degree murder or the lesser included offense of manslaughter with a firearm. A firearm is defined as any weapon, including a starter gun, which is intended to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm, muffler, or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. If you find the defendant committed second-degree murder or a lesser-included offense of manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried or used the firearm, then you should find her guilty only of second-degree murder or the lesser-included offense of manslaughter. Justifiable use of deadly force on page 8. It is a defense to the crime of second-degree murder, including the lesser-included offense of manslaughter, if the actions of the defendant constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. The defendant does not have the burden of proving that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. The law on justifiable use of deadly force is as follows. Defendant was justified in using deadly force if she reasonably believed that such force was necessary to prevent A, imminent death or great bodily harm to herself or another, or B, the imminent commission of burglary or false imprisonment against her or another. If the defendant was not committing any crime, other than the alleged second-degree murder or any lesser-included crime for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had a right to be, then the defendant had no duty to retreat before using deadly force. On the other hand, if at the time the defendant used deadly force, she was committing second-degree murder or manslaughter, or if at the time the defendant used deadly force, she was not in a place where she had a right to be, the defendant had a duty to retreat. The duty to retreat means the defendant had the legal obligation to use every reasonable means to avoid danger before using deadly force. The law does not require the defendant to retreat if she was placed in imminent danger of great bodily harm or if she was placed in imminent danger of death or great bodily harm, of imminent danger of the commission of burglary and or false imprisonment against herself and or others, and it would have increased her own danger to retreat, or if retreat, it would have been futile. But if the defendant had a duty to retreat and she could have safely retreated, but did not do so, then her use of deadly force was not justifiable. If the defendant was in a dwelling or residence in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to herself or another, or B, the imminent commission of burglary or false imprisonment against herself or another. Burglary is defined as follows: entering a dwelling owned by or in possession of another, and at the time of entering the dwelling, the unauthorized person had the intent to commit the crime of false imprisonment. Dwelling means a building of any kind, whether such building is temporary or permanent, mobile or immobile, which has a roof over it and is designed to be occupied by people lodging therein at night, together with the enclosed space of ground and outbuildings immediately surrounding it. The enclosure need not be continuous, as it may have an ungated opening for entering and exiting. For purposes of burglary, a dwelling includes an attached porch or attached garage. False imprisonment is defined as follows: to forcibly or secretly confine or abduct another person without lawful authority to do so. Secretly means the defendant intended to isolate or insulate. Secretly means the victim in this case, Pedro Jimenez, so that's a typo, intended to isolate or insulate the defendant and or the minor child and or the minor children from meaningful contact or meaningful communication with the public. I'll repeat, that was a typo. So secretly means the victim in this case, Pedro Jimenez, intended to isolate or insulate the defendant and or the minor child and or the minor children from meaningful contact or meaningful communication with the public. Confinement of a child under the age of 13 is against the child's will if such confinement is without the consent of the child's parent or legal guardian. In deciding whether the defendant was justified in the use of or deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances must have believed the use of deadly force was necessary. The defendant is presumed to have held reasonable fear of imminent peril of death or great bodily harm to herself or another when using defensive force that was intended or likely to cause death or great bodily harm if A, The person against whom the defensive force was used in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle, and B, defendant knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. The presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person against whom the defensive force is used has the right to be in or is in a lawful resident of the residence, such as an owner, lessee, or title holder, and there is not an injunction for protection from domestic violence or written pretrial supervision order of no contact against that person, or the person or persons sought to be removed is a child or grandchild, or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used, or C, the person who uses defensive force is engaged in a criminal activity or is using the residence to further criminal activity, or D, the person against whom the defensive force is used is a law enforcement officer who enters or attempts to enter a residence in the performance of his or her official duties, and the officer identified himself or herself in accordance with any applicable law, or the person using the force knew or reasonably should have known that the person entering or attempting to enter was a law enforcement officer. A person who unlawfully and by force enters or attempts to enter another residence is presumed to be doing so with the intent to commit an unlawful act, force, or violence. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporary or permanent or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Residence means a dwelling in which a person resides either temporarily or permanently, or is visiting as an invited guest. Vehicle means a conveyance of any kind, whether or not motorized, which is designed to transport people or property. If you find the defendant who, because of prior threats or difficulties with Pedro Jimenez, had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Pedro Jimenez, you may consider this fact in determining whether the actions of the defendant were those of a reasonable person. On page 11, in considering the issue of self-defense or defense of others, you may take into account the relative physical abilities and capacities of the defendant and Pedro Jimenez. Parental rights. This court has taken judicial notice that there are no court records in Miami-Dade County terminating the parental rights of Pedro Jimenez. Instruction on edited recording. You heard a video recording. The court instructed you that the recording had been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording had been edited should not concern you in any way and must not impact the way you view and listen to and consider this evidence. Transcripts of recordings. During this trial, you heard a recording and you are now being furnished transcripts of the recording. The recording is the evidence, and the transcripts are provided to you only as a guide to help you follow as you listen to the recording. Transcripts are not evidence of what was actually said or who said it. If you notice any difference between what you hear on the recording and what you read in the transcripts, you must rely on what you hear and not on what you read. Read them. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, and the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Page 13, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence you should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than others. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit to get the witness to testify? Had any pressure or threat be used against the witness that affected the truth of the witness's testimony? Did the witness at some time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of the expert's testimony. You have heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about the testimony of what the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or testimony of any witness. Defendant's statements. Statements claimed to be made by the defendant outside of court have been placed before you. Such statements should always be considered with caution and be weighed with great care to make certain they were freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statements were knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether the defendant made the statements, she had been threatened in order to get her to make them, and whether anyone had promised her anything in order to get her to make them. If you conclude the defendant's out-of-court statements were not freely and voluntarily made, you should disregard them. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice, and there is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. And the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proved guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. And deciding a verdict is exclusively your job. I cannot participate in that decision in any way, so please disregard anything I may have said or done that made you think I preferred one verdict over another. Page 18, verdict. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned to the crime charged. The verdict must be in writing, and for your convenience, the necessary forms of verdict have been prepared for you, and they are as follows. It's pretty simple. Page 2 is the date and the jury foreman. You don't have a copy of this, but I'll hold it up. So it's really a one-pager. You have 3 choices: not guilty, guilty of manslaughter as a lesser included offense, or guilty of second-degree murder. If you find Ms. Ling guilty of any of the crimes, there are interrogatory findings regarding the firearm. So you have to make a finding For the manslaughter, if she actually used the firearm, yes or no are your options. Similar options for second-degree murder. You have the options of whether or not she actually possessed the firearm during the commission of the offense. Also options of yes and no. You'll then go to number 2. Did she discharge the firearm during the commission of the offense? Then you'll go to number 3. Did she discharge the firearm causing death during the commission of the crime? It's pretty self-explanatory. And as I said earlier, the lawyers will have an opportunity to make their closing arguments to you. The state gets to go first. And for the state, we have...
May I please report?
Yes.
Counsel.
Ladies and gentlemen of the jury, on June 25th, 2022, Pedro Jimenez was murdered. He was murdered by his 9-year relationship, his spouse, his wife, his defendant, Daisy Link. Earlier that day, Pedro Jimenez was picked up by friends. Ms. Link knew that. And he went over there and was there for a very long time. And that made Ms. Link angry. He wasn't home. He wasn't spending time with her or his children. He was with friends. He's a trucker. He's never home. Why aren't you spending time with me? Her mother's there. Her children are home. Her mother flew in for a barbecue. Why aren't you spending time with me? And so what does she tell her mother? I'm going to go pick this idiot up. He's probably drunk off his ass. And she goes. She's not afraid. She goes there, unafraid, uninvited. And she waits outside. And minutes pass. And she asks Pedro, where are you? And he doesn't respond. And so she goes inside to look for him, unafraid, not scared, uninvited. And she sees him, and he says, I'm coming, I'm coming. And she pulls him out of the house and takes him home. Their home. Not her home, but their home. And then they go and get beer. They continue acting like a family, a toxic family. No doubt about that. We were the first ones to tell you it was a toxic family. We're the first ones to speak. We're the last ones to speak. It is our burden. But we were very upfront with you, ladies and gentlemen of the jury. This is a toxic relationship. Two people that should have never been together. Ms. Link said Pedro Jimenez was a good guy. I disagree. I don't think he was a good guy. But he didn't deserve to be murdered that day. And so they fight. Why? Because Pedro has his suspicions. He accuses her of cheating. He's never home. This is his wife of 9 years. And he accuses her of cheating. And she denies it. And they continue fighting. And then he backs off. And he accuses her again. And they fight about that. And then he backs off. And they continue fighting. Over and over again. Until Pedro gives up and leaves. Ms. Link already had the gun at that point. And she goes outside to smoke her cigarette. And Pedro comes home. And she sees him. And she says, you know what? I'm done with this. You're never home. You're not around our kids. My mom's here for a barbecue. Which, mind you, happened earlier that day that he missed. You know what? You're right. I did cheat on you. And what does Pedro say? She's holding the gun at that point. He says, as she's pointing the gun at him, do it. Do it then. I want to die. I gave you everything. His voice drops, and he turns and starts walking away. And then he realizes, as the gun is pointing at him, that Ms. Link is serious this time. We heard that they were a toxic relationship. He hit her just like she hit him. And he started to run. And she fired. And it went through his foot, upward manner through his thigh, hitting his ephemeral artery. Pedro had cocaine in his system, yes. He had alcohol in his system, yes. He had marijuana in his system, yes. But we heard from Dr. Mathis that coke actually kept him alive. He would have died faster. So what does Daisy do? She mocks him, belittles him. It's not like I hit a major artery. You'll be fine. A couple seconds pass. As he's running away, fleeing from her, he's the one in fear. You sure you don't want to go to hospital? No. Okay. And then she tosses the gun. She goes back to where she shot, and she picked up the casing that was never found.
Objection, fact not in evidence.
So this is argument of what the lawyers believe evidence showed you. You should rely on your memory of what the evidence was. You can continue.
And then Daisy realizes, wait, my neighbors heard that gunshot. Let me go see where Pedro is. And she goes looking for him. And she doesn't call 911. And she finds him. And he's laying on the ground. He had been running, hiding in bushes, scared. And she finds him. And what does she do? She goes up to his body as he lies there dying, begging for help, asking her, pleading her, call 911.
Objection, facts not in evidence.
Sustained.
And she goes through his pockets, takes his phone, takes his identification, and walks back to the car. And she hides that stuff because she doesn't want anyone to know who he is. Because if they find out who he is, they'll figure out she was the shooter. And so finally she walks back and starts rendering aid because she realizes what's about to happen. He's about to die. And so that is the time that she calls 911. And she lies to the 911 operator. She says, I have no idea who this person is, despite being married to him for 9 years. I don't know what his date of birth is. I don't know how old he is, despite being married for 9 years. I just found this random man. I was walking around in the alley, despite being married to this man for 9 years. Officers arrive, and she asks, Pedro, what happened? What the fuck happened? She knew, and she lied, and she lied, and she lied. Officers were kind to her. They let her go back to the home. This is a spouse. She's scared. They didn't know what was going on at that time until Detective Danny Morales shows up, seasoned homicide detective, and he sees a woman in the middle of the area. He doesn't know who she is, and he approaches her, and she becomes aggressive. In fact, that night she threw a chair at him. So he detains her, and as he detains her, as he pats her down, trying to calm her down, trying to get a hold of the situation, she starts hiding the keys in her pocket. The keys of that same Chevrolet Trax with Pedro's stuff in it that would identify him, that would link her to this crime. Eventually, they bring her to the homicide headquarters. She never denies that they lived together, never denies that he lived there, never denies their relationship. Changes her story over and over and over again. Listen to it. It's an hour and a half long. An hour and a half of changing statements, of changing stories, giving more detail, taking that detail back. We gave you a transcript as well. Read it over. She changes her story over and over and over again. Officers find a firearm, that same firearm that belongs to her. The same firearm that she used to kill Pedro. And that night they arrest her, but that's not where their investigation ends, ladies and gentlemen of the jury. They continue investigating. They find surveillance video that disproves what Daisy Link was saying, that shows Pedro fleeing, hiding, in fear. And they take it back and they try to download it. And because of the program, when it gets plugged back in, it gets deleted. And that's a shame. But it wasn't deleted on purpose. We heard the steps that they took to preserve that evidence. And old technology is old technology. But this defendant murdered Pedro Jimenez that night. So as we heard jury instructions read to you earlier, there are some rules of deliberation about how you should weigh the evidence in this case. And I want to walk through these 8 rules with you all and talk about the state's witnesses first and how you should weigh this evidence. Number 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? Yes. Every single state witness was personally involved in this case or was there the night of the murder, investigated the case, talked about what they did. Each and every state witness didn't say, well, I wasn't there, I don't know what was going on. Everyone was there. Every state witness testified to that. Kevin Bonilla was at the house when Daisy showed up and walked inside to go pick Pedro up. All the detectives were on scene. Canine officers who found firearm. Everyone there saw and testified to what they did. Did the witness seem to have an accurate memory? Yes, they did. It's 3 years ago, sure. But they remembered what they did. They remembered their investigations. Was the witness honest and straightforward in answering the attorney's questions? Yes. This is a trial. There are objections. Some are sustained, some are overruled. Absolutely. But not a single state witness gave a sarcastic comment. Not a single state witness argued. Everyone was very candid with what they did, what they didn't, what they remembered, and they were honest and straightforward the entire time. Did the witness have some interest in how the case should be decided? No. 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 Does the witness's testimony agree with the other testimony and other evidence in this case? Absolutely it does, and we'll walk through the evidence in a few moments, but absolutely it does. Each step officers took agreed with the next step. They talked about how homicide teams work in teams, that there is a lead. That lead gives assignments. The blood trail is consistent with the video that Mr. Cisneros saw, that Detective Morales saw, that Detective Hubbard saw. It's all consistent. Has the witness been offered or received any money for treatment or other benefit in order to get the witness to testify? No. We heard nothing of that. Nothing. Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? No. We heard nothing of that. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Not really, no. They weren't handed a deposition transcript saying, didn't you say this a couple of years ago? Absolutely not. Absolutely not. So when you're viewing the state's evidence, use these rules. When you're thinking about the state's witnesses, use these rules. Importantly, as we heard, as I talked about, as we have all talked about, my burden in this case, I have to prove this case to you. It is my job and my job alone to prove this case. My burden is a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. That is my burden. Just like we talked about in jury selection. If it's wet outside and we heard thunder and it's wet for miles and miles and miles, it is reasonable to believe that it rained. It is not reasonable. We have to imagine, speculate, force ourselves, pretend that a fire truck came and sprayed it for miles and miles and miles. That doesn't happen. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict of the evidence, or lack thereof evidence. And that's a really important point. And we'll talk about that in a little bit. Now, as the judge read, as you have in your hands, second-degree murder, and we talked about this in a little bit during jury selection. What do I actually have to prove? What are the elements of second-degree murder? Number 1, Pedro Jimenez is dead. Number 2, the death was caused by the criminal act of dazedly. Number 3, there was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a deprived mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous and demonstrating a deprived mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or evil intent, and is of such a nature that the act itself indicates an indifference to human life. And importantly, I do not have to prove intent that she wanted to kill him that night. If it meets those three elements, in order to convict of a second-degree murder, it is not necessary for the state to prove the defendant had the intent to cause death. Merely these three elements. So let's talk about these three elements and how the state proved beyond a reasonable doubt these three elements. The first, as you heard, ladies and gentlemen of the jury, there is a stipulation in this case. Pedro Jimenez is dead. There is no disagreement there. And you must take that as true. So the state has proven beyond a reasonable doubt the first element. We're a third of the way there already. 2 and 3, the death was caused by the criminal act of Daisy Link, and there was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a deprived mind without regard for human life. I'm going to take these two together. I think it's important to talk about these two together. And importantly, we can talk about it. There was a lot of testimony about what the timeline is, when they found a gun, when they didn't find a gun, when Daisy admitted to the crime. The timeline is really important. June 25th at 3:06 a.m. A Ring video starts recording. At 3:11, a gunshot is heard. Daisy tells Pedro, "It's not like I hit a major artery. You'll be fine." Couple beats. "You sure you don't want to go to a hospital?" "No, okay." No fear, no adrenaline like she testified to, nothing. Calm as a cucumber. If you pay attention closely to the right-hand side, you actually see Pedro fleeing. Adrenaline? Fear? Nothing. Cavalier attitude. Anger, hatred. Pissed off as hell. Not adrenaline, calm. And discuss Pedro's statement before she shoots. Do it. I want to die. I gave you everything. That is a man who is broken by his wife of 9 years. It is not him charging at her. It is not him screaming at her. This isn't an assisted suicide. This is, you're pointing a gun at me. Nobody says, do it, I want to die, while there's a gun below you, hanging off the side. This is a man who has a gun in his face, steps away from this defendant. Do it then. Do it. I want to die. I gave you everything. You broke my heart. You just told me you're cheating on me. This is a toxic relationship with domestic violence going back and forth. And you know what Miss Link did? She lit a match and lit that fire that night because she wanted this relationship to be over. And this was the best way to do it. This was a broken man. Maybe a drug addict, never home, not really seeing his kids all that much. A broken man. He just found out that his wife was confirming his suspicions the entire time. 3:21. 10 minutes pass. Daisy Link calls 911 and lies about who he is, who she is, everything else.
Today, June 25, 2022, 03:21 and 57 seconds.
I am in that fire. What is the emergency? Sorry. Yeah. I don't know. I can hear about freaking. Okay, down on my computer. I check the phone to see where you are. Do you know what happened to him?
I have no idea. He's bleeding everywhere.
Is he awake and breathing? And place here at 1300. What is my weight down? Where? Where? Are you in Homestead now? Yes. What is the phone number you're calling from? What did I say? 52 95 9656 so that you get home police as well. Fire is already from.
Lie after lie after lie after lie after lie. 3:27. 6 minutes. 6 minutes after she calls 911, Officer Nicholson arrives first on scene, and she lies to him. And what does she say to Pedro, despite knowing exactly what happened? Pedro, what the fuck happened? She knows. She shot him. She pointed the gun at him and discharged it as he ran away. What the fuck happened, Pedro? I shot you is what the fuck happened. Officer Nicholson asked, Pedro, what happened? And she says, if you listen closely, I hit a major artery. Listen to it carefully. This is his body-worn camera. She says, I hit a major artery. That's an admission, ladies and gentlemen of the jury. She shot and fired. And it links up directly to her statement earlier, where she mocked him. It's not like I hit a major artery. She knew what she was doing. She was aiming that gun on purpose. This is not a ricochet. It didn't hit the ground, bounce up. She shot it at him as he fled. We actually see Pedro Jimenez's last breaths ever. We watch him die. You're coming. His last moments on earth. His wife pretends he didn't know that she murdered him. Victim pronounced deceased at 3:40 a.m. Officer Rodriguez speaks to the defendant, who again lies to him. He left in a van. I don't know who his friends are, despite going there earlier in the day and picking him up. The van that officers wasted precious time searching for. She sent them on a wild goose chase. Later on, homicide detectives arrive. 5:40. 6:30. Daisy's sister shows up and says, "Oh, if he's dead, Daisy did it." She knew. But she knew that it was a toxic relationship. She knew that Daisy hit Pedro and Pedro hit Daisy. That Daisy was going to light a match eventually. She knew. Between 6:50 and 8:30, detective crews canvass the scene of Pedro's murder. They walk the scene, they take photographs, they try to figure out piece by piece what's going on. They don't find a gun. 9:20 a.m. when the defendant enters the room. That's how aggressive she is. I'm not putting that shit on. Covered in blood. Angry.
If there's no run on the person, I gotta see for that.
I'm not putting that shit on. She even goes on to say at 3:52 in that hour and a half video that you have in evidence, why are you treating me like I did this? Why are you taking pictures of me like I did it to him? She says at 4:08, the bruises are from a car accident, which she confirmed, by the way, on the stand when I was cross-examining her yesterday. She says the bruises don't apply to this, trying to make it seem like he would hit me. Lie after lie after lie after lie. At 12:27, canines locate a firearm. I'm sorry. At 12:27, a residential search warrant is executed for Daisy and Pedro's home. And what do they find, ladies and gentlemen? Look closely. Men's shoes, men's clothing, adult men's clothing. Pedro lived there. It was his home. Same time, canines locate a hidden firearm. Hidden firearm. That was about the only honest thing she said that night, that she hid that gun. And it was her gun. And it's not until 3:39, 4:20 that the defendant begins to start hearing. We know that, not just because we heard it and we can see it on video. The time of when she waived her Miranda rights and chose to speak to officers is actually memorialized on that Miranda form itself. You have the right to remain silent. You don't have to talk to me if you do not wish to. You don't have to answer any of my questions. You understand that, right? Yes. Should you talk to me? Anything which you say may be introduced into evidence against you. Do you understand? Yes. If you want a lawyer to be present during questioning at this time or any time hereafter, you are entitled to have a lawyer present. Then, yes, you cannot afford to pay for a lawyer. One will be provided for you at no cost if you want. You understand that, right? Yes. And then she waives. She voluntarily spoke to them. Says a lot of very interesting things during this statement. But I think what's most interesting here is her demeanor during this. She's crying, she's sad, she's scared, until she's confronted with one of her lies. And you can actually see her demeanor change. She's not scared anymore. She's mad. You see her demeanor change when officers catch her in a lie. What if I have you on video saying, it's not like I hit a major artery, you'll be fine? Her change in demeanor is important here. What else does she tell us? I was angry. Doesn't say I was scared. Not talking about something that happened 5 days ago. I was angry. What did she say about the shooting? One of the 5 different stories she tells that night, and yesterday as well.
Yeah. It was down, and once he said, "Oh, you're gonna sleep outside tonight," which that's not how you just picked it up, and I just cocked it, and I shot it. It was already cocked and everything. I shot it.
Catch that? It was already cocked. He says, you're sleeping outside. I lifted it and I shot. It was already cocked. She was outside, not scared. Her with the deadly weapon. We know Pedro never had the gun. We know he never had a weapon. She said as much. At 5:03 is when she tells officers where the firearm is. 5 hours prior, though, K-9 already had located it. She wasn't being helpful. They already found it. They were already piecing the picture together. As she's being interviewed, they're doing their work. They find this ring camera. They find the firearm. They're doing their job. They're watching video. The defendant is eventually arrested that day, and then on June 26th, a secondary canvass is conducted with other K-9 officers. They don't find him. They don't find the casing that Daisy Link hit, because she didn't want to get caught. We also know, based off a subsequent search, Pedro's path that night. Well, let's talk about this. We heard not from one, not from two, not from three, but 4 officers about that video footage at Robert Cisneros' house. We heard from Robert Cisneros himself. It's an older model DVR. It's plugged in, it's hardwired. I saw it with my own eyes. I saw the victim running, hiding behind bushes, running and then collapsing. A woman passing by, going to his body, manipulating his body, walking away, coming back. We actually can piece together his path based off the evidence, the CSI photos, the blood spatter. We know that Daisy's house is where he got shot. I'm sorry, Daisy's house. This is the porch. What's important is those 2 doors. He said that he was charging at her while she was on the floor. Where? How? That's what she tells us. And after he gets shot, he runs this way. We know that from the blood spatter. Daisy walks this way. You'll be fine. Not like I'm going to be. Not like I hit a major artery. You'll be fine. And he continues running. And we actually see that in that same video. And blood spatter continues. We know, again, that he travels up through the alley. So he gets to this car. Blood spatter again. Before collapsing and dying. Right here. And look at where the Chevy tracks is. Look how far away it is. Daisy would have had to have walked feet after feet after feet to get to him and hide his stuff back in the car. It took her time. It was deliberate action she was taking, but she didn't want to get involved. And we can also piece together Daisy's path that night as well. This is their home. She shoots and fires. He's running away from her. She goes this way, the trampoline. She says, not like I hit a major artery. You'll be fine. Beep, 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 beep. You sure you don't want to go to the hospital? You'll be fine, okay. And then she comes back and she hides the firearm. Her firearm. She has to come back, get in her car, and drive. And she waits. She doesn't call 911. There was just a gunshot. She knows she hit him. She doesn't think she hit him where she hit him, but she knows she hit him. So she goes to look for her husband of 9 years. She's not afraid of him. She's not scared of him. She's not thinking about an incident that occurred 5 days prior. This is a toxic relationship, and she just lit the fuse. I cheated on you. You're right. You're never home. So she says, my husband of 9 years, I just shot. Let me go find him. You can't take back a murder. Her rendering aid, attempting to render aid, lying officers are relevant. Rendering aid is hero. You can't take back a murder. She goes this way, up, and back. We know she doesn't go this way. There's a car lot. You know, it's not this way. It's her car, and it's over here. And it's important. She goes this way, up, and she walks over to Pedro's body, turns her car off, and takes his items out of his pocket. His phone, his money, his keys. She goes back and starts rendering aid. It took her time. These are deliberate steps that she took. shot itself. He was running away. With his foot out through his ankle, and then through his thigh. In, out, in, out. It was a clean shot. It was a good shot. The only way that shot makes sense with one shot, from what we heard from Dr. Mathis, is when somebody is running away. That's the trajectory that it took. That is the only way that that is possible. And if it missed the foot, it's still going through the thigh either way. It's still hitting that artery either way. This didn't bounce off the floor through his foot, ricocheting, and then ending up in her thigh, or his thigh. It was a good shot. Again, we can see Dr. Mathis' work. Entry, exit, entry, exit, through the femoral artery. And how do we know that it was Daisy's gun? Pay attention. Pay very close attention. Earlier in the day, we get back to the shot. What's in her hand? The firearm she hid. She got that gun. It was her gun. How do we know it's her gun? Well, we heard from criminalists from the Miami-Dade crime lab that they tested it for DNA. And the majority of that DNA belonged to none other than the defendant, Daisy Link. And how do we know that? The statistic they came up with. 1 in 28.71 septillion. That it is her DNA. Septillion is 24 zeros. That's not a small number. The population of Earth is 8 billion. That's 24 zeros. It's her gun. Talk about reasonable doubt again, and this is so important because I'm about to talk about the defense witnesses. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. A reasonable doubt as to the guilt of the evidence of the defendant may arise from the evidence, conflict of evidence, or lack thereof evidence. And what's important here, ladies and gentlemen of the jury, there's actually no reasonable doubt for the state's evidence. But when you look at conflicts of the evidence, you should also take a look at the evidence that the defense presented. And to be clear, they don't have to do a single thing. Her attorney never has to open his mouth. I'm the only one that has to do anything. But they gave us interesting evidence, interesting testimony. And you weigh that evidence, that testimony, the same way you weigh the state's evidence. Did the witness seem to have an opportunity to see and know the things about which the witness testified to? Absolutely not. Absolutely not. We heard from her niece, Laylin, who lives in Texas, who flew to Florida 4 days prior. And what did she do? Well, I went to my aunt Crystal's house and we hung out. And then there was a barbecue a couple days later. And I saw some injuries to Daisy, but I can't tell you where those injuries are from. I don't know what day it was taken. I wasn't there the night that he was killed. Wasn't there when he got shot. She wasn't there. We heard from Crystal. Same thing. Same thing. And she even admitted she didn't know if Pedro lived there or not. Crystal pretended like she knew. Excuse me, Laylin pretended like she knew, but she was challenged on that. You're not coming in to Florida often. You live in Texas. You don't know. It's entirely reasonable to believe that when Pedro comes home, your aunt's not telling you, hey, my husband's home. She has no idea. Her mother testified as well. She left. They said it was such a dangerous situation, she left her grandchildren with such a dangerous man. She watched her daughter get choked, nearly murdered in front of her, and she leaves? It's one thing to say, I can't control this 30-year-old person. If they want to do what they want to do, they're going to do it. It's an entirely different thing, though, to leave an 8-year-old and a 5-year-old in that situation. Because it didn't happen. Did the witness seem to have an accurate memory? No. Crystal denied making a statement to Detective Morales, but then challenged. She goes, well, actually, I didn't. For confrontational, I think Crystal even said, how would I know I'm not safe? Did the witness seem honest and straightforward in answering the questions? Absolutely not. Same thing. Crystal said, I'm not a psychic. How would I know? Well, it's your sister, right? Shouldn't you know about her abusive husband? You know about the toxic relationship. You know she hits him and he hits her. But you're not a psychic. You can't put one and one together. You know your sister has a gun. I just showed you it's her gun. Did the witness have some interest in how the case should be decided? Does the witness testimony agree with the other testimony, other evidence in this case? Has the witness been offered or received any money for fear treatment or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the treatment of the witness's testimony? Let's talk about Pedro Jr. for a second. And his testimony being so critical. What did he tell us? I'm here to get my mom out of jail. Here to get my mom out of jail. I live with my grandma. I talk to her at least about this case. I forget. What happens? Sometimes I say daddy shot twice 5 days before, but no, grandma wasn't there, mind you. Corrects me. If they're willing to coach a child on what to say, it is very reasonable to believe that they have been coordinating their testimony to. They weren't there, they don't know. And a child has admitted. Children are pretty honest. And honestly, Pedro Jr. seems like a great kid. Really honest. He said, when I make a mistake about the night, that my grandma wasn't there. She tells me what happened. Wasn't there. How does she know? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Absolutely. How many times did they get impeached with their own depositions? Let's talk about the lease agreement. Now, this is an older one. And I want to bring to your attention 3 major things here. Tenant's email address, pete89.pj@gmail.com. Phone numbers, top right, my copy. My copy, not original. Not sent, not filed one, my copy. And then right here, where it says Daisy Lane, pay very close attention to this line. What does that look like? That looks like whiteout. My copy. As you make it out, you can actually kind of see Pedro Jimenez's name right underneath it. But that's consistent with being whited out on her copy, not the original, her copy. Let's talk about the newest lease as well. Defense Exhibit D. Well, ladies and gentlemen of the jury, Pedro's name's not on here. You know what's also not on here? Any signatures? How do we know this wasn't updated? There's no initialing. There is no signatures, no dates, no times. How do we know? Let's talk about earlier in the night. They said the toxic family, toxic evil man. I'm sorry, actually, let me back up. They said he was a good guy. That's what she said. He was a good guy. Not the family, though. They came to rescue her, but they waited for days. They were there, they were having a barbecue. They flew in the middle of the night. They were their grandchildren. So we had Daisy picked Pedro up on her own volition, mind you. Pedro holding a beer. Who shows up? His children, her children, their family. They are a family. No fear. Not being scared. They are a family. Even later, the victim returns to the car. Probably left some stuff in it. After all, he rented that vehicle. Who walks back to the car with Pedro and Daisy? I showed you this a few minutes ago. Pay attention to what's in Daisy's hand. Gun. That same gun. Her gun. Daisy told us an interesting lie yesterday, and her mother did too. That was completely refuted by actual evidence. They said that Pedro punched through a wall and opened this door. Well, good thing we have photographs. Tell me where the broken window is. Even if he punched through that, look, I'm not the biggest guy in the world. I don't believe in superheroes. I don't think Pedro is Mr. Elastic. He can't open that door from there. There's no broken window. There's no punch window. That didn't happen either. Lie after lie after lie after lie. Another really important thing. Let's talk about what happened 5 days prior. I believe something happened. Hell, we have pictures. I absolutely believe something happened. But not what Daisy said. Pedro Jr. was coached on what to say. How do we know that? Well, Daisy actually told us. She has cameras. They record things. That would have happened on or about the 20th or 21st. And what's really interesting here is the conveniences. It is really convenient. We have the 18th, the 22nd, and then the night of the murder. This is from her phone. Isn't it convenient how that video doesn't exist? Isn't it convenient? What actually happened that night, ladies and gentlemen of the jury? Actually happened that night. That's what happened. She was mad as fuck. Pedro's never home. On the road all the time. Off getting high. I was mad as fuck. Ladies and gentlemen of the jury, the state has proven beyond a reasonable doubt the death was caused by the criminal act of Daisy Lane. She pointed the gun that we already pointed at when we made those statements. So he fled, he ran, she fired at him. She actually made a very surprising omission yesterday when she said that she didn't think she was going to hit him. She pointed and fired with purpose. That yesterday, contradicted by her own statement, which is full of its own contradictions over and over and over again. I didn't think it was going to hit. It is proving beyond reasonable doubt. Element 2. Element 3. There was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a deprived mind without regard for human life. Pointing a firearm and shooting it is imminently dangerous. Deprived mind, I don't know what's more deprived than after you shot someone mocking them. You'll be fine. Not like I hit a major artery. You'll be fine. After breaking this man's heart and lighting that fuse. Talk about lesser. Oh, let me back up. After the state has proven element 1, element 2, and element 3, state has proven beyond a reasonable doubt that the defendant is guilty of second-degree murder. As you heard, there are lesser included offenses in this case. Lesser included offenses are offenses that make up the actual charge, but they're smaller. There's less there. And as you heard, in this case, it's manslaughter. What do we have to prove for manslaughter? That Pedro Jimenez is dead. That we all agree. You have to take that as true. We all agree. 2, Daisy Link intentionally committed an act or acts that caused the death of Pedro Jimenez. She lifted the gun. She pulled the trigger as he ran. As an act that caused the death. We heard Dr. Mathis say, cause of death, manner of death, homicide, gunshot wound. Daisy Link did that. I've already proven to you, beyond a reasonable doubt, that this is a second-degree murder. But I've also proven manslaughter as well. Aggravation of a felony by carrying a firearm. This is important too because you will have a verdict form that you will have to make certain decisions on. If I've proven my case, you must make the determination beyond a reasonable doubt that Daisy Link actually possessed the firearm during the commission of the crime. She's admitted that. Whether the state has proven beyond a reasonable doubt that Daisy Link discharged the firearm, she's admitted that. Whether the state has proven beyond a reasonable doubt that Daisy Link discharged the firearm and in doing so caused death or great bodily harm to Pedro Jimenez, he's dead. Proven that. This is really important too. Justifiable use of deadly force. Self-defense. That's what this case is. That's the defense that they have put on. The defendant was justified in using deadly force if she assumed reasonably that such force was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of burglary to a dwelling or false imprisonment against herself. I'm not going to talk about those because there's no evidence of those. But let's talk about imminent for a second. I had a conversation with Mr. Cruz during jury selection. I threatened him, remember? We were at Publix in the line. I cut him. He said some words to me. I said, I'll see you outside. I lifted my shirt. I showed him my gun. Imminent. It is happening right there, right then. Not 5 days before, not hours before, right then, right there. There was a lawyer on the panel who mentioned a bus 200, 300, 400, whatever it was, feet away. And he said, that is imminent. No, it's not, because there can be an intervening cause. Car accident. Imminent. Right away. So as the judge showed you, your verdict form will look a little like this. I couldn't fit in the signature line for the foreperson in the data crime, but this is what you'll get. This is something you'll get. And you're going to have to make a decision here. Guilty of second-degree murder, guilty of manslaughter, or not guilty. Well, again, I've proven my case beyond a reasonable doubt. So check off second-degree murder. And as we talked about already with the aggravation of a firearm, she did actually possess a firearm. She did discharge a firearm, and she did cause death. That's what your verdict form will look like, ladies and gentlemen of the jury, because there is only one verdict in this case that is consistent with the evidence, consistent with the facts of this case. And the only verdict that justice demands, and that's this defendant, Daisy Link, is guilty of second-degree murder. Thank you.
Thank you. And now for the defense.
In the signature line for the foreperson in the data crime, but this is what you'll get. This is something you'll get. And you're going to have to make a decision here. Guilty of second-degree murder, guilty of manslaughter, or not guilty. Well, again, I've proven my case beyond a reasonable doubt. So you check off second-degree murder. And as we talked about already with the aggravation of a firearm, she did actually possess a firearm, she did discharge a firearm, and she did cause death. That's what your verdict form will look like, ladies and gentlemen of the jury, because there is only one verdict in this case that is consistent with the evidence, consistent with the facts of this case. And the only verdict that justice demands, and that's this defendant, Daisy Link, is guilty of second-degree murder. Thank you.
Thank you. And now for the defense?
Can we take a quick comfort break to start this up?
Sure. Why don't we do this? Why don't we go to the jury room for a few minutes and we'll come back out and then we'll do the other closing.
All right, for the jurors, watch you step down. The jury room is different.
You give them the time that they used up? You tell the state how much time they used up?
Sure. I get the switch, and then they go to a break. Dang it! So
we have 7 minutes. So we used up 53 minutes. Okay, that's fine. You're keeping time. All right, folks. We'll be back in a few minutes. Who offered it? Did you figure out who ordered the chicken?
I figured they'd take a lunch. I don't know why they just don't take a lunch right now and then come back for defense. Why don't they just take a lunch? It's 12:38. Just take the lunch. All right. Did you guys like that little switcheroo there? I saw that CTV had it, and that's the guy from the guy that was in the plaid shirt. Whoa. All right, camera guy. Take it easy there, buddy. Take it easy there. And the audio is so much better. So it's fun. We can, I want to see, okay, there's the guy in the plaid shirt. Let's see him moving the camera all over the place. Hold on. He's like moving that camera all over the place. So I got a two camera feed. Ooh, I get to switch back and forth. I got a 2-camera feed. So the guy in the plaid shirt there, he's the camera operator. I got a 2-camera feed. I feel like a director. I feel like I'm directing a Hollywood movie here. 2-camera feed. I should probably hold on. Definitely would do this. Don't want that. If we're going to do this 2-camera feed, we could do that. Switch back to this. Oh, yes. All right. I'm going to go crazy with this power now. This is better. At least we get to see the courtroom. That's kind of fun, right? But at least we have good audio. Yes. The camera guy looks sketchy. He's a camera operator. He's tech. They're allowed to look sketchy. That's what. I'm surprised he's not all in black. Usually camera people usually wear all black to fade into the background. You usually don't wear clothes that will make you stand out. You usually wear black, especially if it's a nighttime event, like if you're doing any kind of seminars or anything in a conference, large conference room or auditorium. You wear black, so you fade into the background. Yeah, this is definitely more exciting to look at people walking around. Yes, exactly. I am on a power trip. All right, let's go over. What'd you guys think? Did they meet their burden? I can get rid of state's closing argument. That's over with. Did the state meet their burden? Let's see what you guys thought. He is no Newton. That is true. Chris, the director, right? All right, hold on. Let me end this poll. All right, Super Bowl. You're okay. And Super Bowl's up. All right. Super Bowl, moment of Super Bowl. Meow. Yep. All right. So, has the state met their burden? Let's see here. Yep. Nope. You can't. You just got. If you're gonna, you gotta keep it moving. Keep it moving. Keep it moving, kid. All right. All right, let's see. 174 votes. Has the state met the burden? 65% of you say yes, Daisy is guilty of second degree. 28% say I would vote manslaughter. 7% say she's not guilty. All right. Let's go through their closing here. So she was angry because Pedro wasn't home with her and the kids. He was with his friends and not her. It's a toxic family. Two people that should have never been together. She said Pedro was a good guy. I disagree, meaning the prosecutor. I don't think he was, but he didn't deserve to die. I want to die. He turns away and walks away. He was pretty adamant about that. He hit her just as much as she hit him. He tries to run as she fires. So, Richard, you sent us that study that law enforcement did that, in your mind, you're saying, I'm going to shoot, and then that person turns just as you can't stop it. You can't stop. Even though you haven't pulled that trigger yet, your mind has made up that decision, and that person turns, and it's too late. It's too late. She, I don't know if she raised the gun full on or if she was just kind of shooting from the hip or whatever she was doing, but I still don't see him running as fast to get these, I still don't see him running that hard because we saw him kind of scurry away in that, in the ring video after she shot him. He kind of right? She shoots him, then he scurries away. So I guess he's not going to be running full on. So I don't know. It just seemed like there wasn't enough room for him to run that hard. Because to run that hard, to get your leg up like that, you've got to be that's a sprint, right? That's a full-out sprint. That's not just a quick little jog. That's a full-on sprint. So for him to be sprinting away, and it takes you, 5-10 feet just to get to that point, right? Who are the runners in chat? Psychosaurus Rex, you jog, right? Or you have you run, right? How long would it take you to get to that position? You just don't start off with your leg up like that, right? It takes you 4 or 5 steps to get your leg up like that. So what do you guys think? It didn't seem like there was enough room for him to be for him to get up enough speed to be doing that. But I don't know. It's just weird. It's just weird. So tell me what you guys think. How long does it take? That's him. Woke. That's Pedro. That's Pedro. Pedro on the table. That shows the wound. So entered his left heel, his left foot outside to in, and then went into his right thigh inside to out. So went out, in, out. Exit wounds. So, and then in order for that to happen, I think and we saw they actually pulled up a dummy and that corroborated what we were thinking, that his leg had to be up like that. That's the only way that he could have gotten shot. So, do you think his leg would, do you think he could get up that quickly? I don't know. I'm having, that's something that I'm having a little tough time with. All right. Let's see. So he starts to run. She calls 911. She lies that she doesn't know him, doesn't know how old he is. That's weird, right? That was really weird. Yeah, Daisy did say that he was 6'4", 240. I do remember that. I do remember her saying that. But then we watched we watched that body cam, and he does seem like he's pretty big. Remember the body cam? We see the body cam, and he does look like he's pretty big. Let's see. So the state doesn't have to prove intent. All they have to do is Pedro is no longer with us, and Daisy, and it was caused by Daisy. That's all they have to really prove. Oh, imminent danger and depraved mind. Then they go over the ring video. She's calm. Oh, you'll be fine. Then he's like, the state's saying he's a man who's broken. No one says do it when a gun is at somebody's side. You just told me you were cheating on me. She lit the match because she wanted to end the relationship. He was a broken man, maybe a drug addict, but not home much. But 10 minutes passed before 911 is called. She says, I hit a major artery. That's an admission. I lifted it and shot. Again, another admission. You sure you don't want to go to the hospital? Nah, you'll be fine. So they're saying it's kind of like the
typo on page 9. You all should have another copy, right?
This one?
Yes, it's a single page. I've already swapped it out in the one that I read into the record and the copy that will go with the clerk report as the official jury instructions. I'm going to ask the jury in front of all of us to swap out page 9 for their copy for the clean copy Lisette's going to give them. They're identical copies. I like for them to have their own copies. Does anyone have an objection to them taking back their own personal copies of the jury instructions?
No objection.
Okay, so can I bring them back in? Yeah? All right, let's bring them back in.
All right, for the jurors.
All 9 jurors are counted present for. We can be seated. Everyone can be seated. Defense lawyers, states, defendant are present. Alrighty, folks. Before we go into Mr. Tomas's closing, page 9 of your instructions, you need to swap it out. There was a typo that I read the correct wording into the record, but because we're allowing you to take your own copies back with you, and so take out page 9, give it to Lisette. If you need a staple, I know this is getting very technical. If you need a staple or paper clip, let us know. All right, Lisette. All right, all 9 jurors are counted present for. We can be seated. Everyone can be seated. Defense lawyers, states, defendant are present. Alrighty, folks. Before we go into Mr. Tomas's closing, page 9 of your instructions, we need to swap it out. There was a typo that I read the correct wording into the record, but because we're allowing you to take your own copies back with you, and so take out page 9, give it to Lisette. If you need a staple, I know this is getting very technical. If you need a staple or paper clip, let us know. All right, Lisette. Lisette, see if they want a staple. You can give them paper clips too. No? We have paper clips up here too.
Do you guys want me to stay at this angle, or do you want me to go to the other one? Do you like this one? This angle or this angle?
Then that's another story.
So should I stay here? I'm not sure if the audio is any... Actually, the audio is better at the other one. So do you want me to stay with the better camera angle or the better audio? I think the audio is a little bit better on the other one. So let me know what you guys want to do. You You want to go with the other one? That has better audio. I think this one audio might be a little bit. This has the better video, but the audio is better. Want me to stay here? This one? You want the better sound? I think the sound is better on the other one. I think. You want the wide one? All right.
The cat is presumed innocent. You're not convinced that the cat's guilty, right? No, I haven't been convinced. Okay.
My favorite clips up here too. Detention opportunity. Everyone swapped out for 9. Thank you all for your continued attention. Now the defense will have an opportunity to give their closing argument.
Good afternoon, everyone. So, as you already know, Miss Link is presumed innocent. You are required to presume that she is innocent. And that presumption is to stay with you throughout this trial until you go back there and deliberate. When you're back there deliberating, if you decide that the state has proven their case beyond all reasonable doubt, then that's another story. But she doesn't lose that presumption until you reach that decision, if you reach that decision. I don't know if you remember, because it's been a couple of weeks already, but during jury selection, there was a juror sitting in the back, in the corner, and we were talking about that example that I gave about the cat and the mouse and the hole in the box. Do you all remember that? Okay. There was this one juror, he was sitting in the back, and he said, I can't make a decision because I don't have enough information. Well, as I explained to him, the cat is presumed innocent. You're not convinced that the cat's guilty, right? No, I haven't been convinced. Okay, well then, your decision is not guilty. He's presumed innocent, so your verdict, right? Your verdict is not guilty. If that changes, if you're convinced otherwise, then you change it. But if you're not, the verdict is not guilty. It's pretty simple. I would submit to you that right now, before I say another word, every single one of you should vote not guilty. I'll explain in a moment, but you should, because the state has not overcome the reasonable doubt in this case. Now remember, I will remind you, I don't have to prove that Ms. Link was justified in pulling the trigger. They have to prove that she was not justified, and they haven't. Now, I want to talk a little bit about some of the things that the state said a moment ago. They said a lot. They said that Daisy was upset because Pedro wasn't home. There's no evidence of that. They just made that up. There is no evidence of that whatsoever. Whatsoever. Point to one witness, one piece of evidence that establishes that. You won't find it because it hasn't been introduced. It's their burden to prove it. They want to say something, they want to allege something, they have to prove it. They can't just get up here, say it, and say, oh, you got to believe us because we're the state. Believe everything we say, believe nothing that the defense say. We're the good guys. Doesn't work that way. They have to prove it. Daisy's mother flew in for a barbecue? That's what he said. You know that's not true. And they didn't even have that barbecue. And yes, they were going to have a barbecue the next day. You heard why. Number one, because she lives in Texas and she has other family that she doesn't get to see, so she's going to see them. And number two, they don't want to make it obvious that Daisy's leaving because they don't want Pedro to flip, which he did anyways. But they don't want him to flip, so they're doing it in a way that he won't find out. That was the testimony. Have they rebuffed that testimony? Have they proven that it's not true? No, they haven't. The most that they've done is, well, maybe it's true, maybe it wasn't. Have they disproven it? They have not. Can you point to a single piece of evidence to testimony, to anything that rebuffs that, you cannot, because it doesn't exist. The state mentioned about phone calls between Pedro and Daisy. Pedro didn't have a phone because he tossed it after he almost beat Daisy to death a few days before. And then he had to get another phone, and you heard testimony about that. You heard testimony about that. When he went to his friend Kevin's house to do all that coke and to buy all that cocaine so he could have a party while he's driving a big rig across the state, snorting cocaine, he didn't have a phone. He didn't have a phone because he tossed the phone after he almost killed Daisy a few days before because he didn't want the police to track him.
Objection, that's not evidence.
It wasn't evidence. She testified to it. I'm not making it up. I'm telling you what was in evidence. You can use your own recollection about what you heard, but we all know that that came out in evidence. I'm not making it up. The state has repeatedly said that was their home. No, it wasn't. They can't just say it and say, there, we proved it. They haven't proved it. This thing is really blurred, but for the future reference, this is Defense Exhibit A. It is 3 pages long. Pedro Jimenez had 2 driver's licenses. These driver licenses, both of them, can't see it here, but you can see it yourself when you go through the evidence. Both of them have his mother's address. You have seen lease agreements where he is not on the lease documents. You have heard testimony from multiple people, including his son, that said he didn't live there. But most importantly, this is Exhibit F, Defense Exhibit F. It's horrible. You can look at it when you're delivering. This is a court order. A court order. Now, the judge read the instructions, and I'm going to tell you exactly what the instruction that she read to you says. And I am talking about page 11 of the instructions, which you will all have with you in the back. Parental rights. The court has taken judicial notice that there are no court records in Miami-Dade terminating the parental rights of Pedro Jimenez. That is right. During my opening statement, I told you he lost his parental rights. I didn't say terminated. I said lost. When your parental rights are terminated, that means it's terminated. That means there's no coming back. They're gone. When you lose your parental rights, you can get it back. And this order provides a pathway for Pedro Jimenez to get his rights back. You know what that pathway is? First page, bottom. Substance abuse assessment, individual therapy, parenting therapy, domestic violence. Domestic violence. September 20th, 2019. Ever since September 20th, 2019, that man was limited to seeing his children by court order 1 time a month under the supervision of his mother, who you've heard doesn't even live in this state. And you've heard no evidence or any indication that she ever came back, because she didn't. And he gets to have FaceTime calls with the children at the sole discretion of the mother. The sole discretion of the mother. Do you think courts and judges limit a parent's ability to see their children flippantly and for no reason? They did it because Pedro Jimenez was a drug addict, a cocaine abuser, an alcohol abuser, and a wife-girlfriend abuser. And as you've heard throughout the course of this trial, he was doing nothing to get those rights back. He was doing the opposite. He was on his way to losing them permanently. Why? Because 5 days before he died, he beat Daisy Link halfway to death. Beat her halfway to death, smashed her skull in, did it in front of his 7-year-old son, did it in front of his 5-year-old daughter, did it in front of 4 other kids who were present. The state got up here and told you Pedro was not dangerous? Are you kidding me? Is that not the very definition of a dangerous man? He proved what he's capable of just 5 days before this happened. The state said a lot of things during their closing. I didn't agree with any of it except for 2 things. One thing that they acknowledged, Pedro was not a good guy. I agree. No, he wasn't a good guy. No, he was a cokehead, wife-beating lunatic. That's what he was. He terrorized and traumatized Daisy Link. He terrorized and traumatized his own children, and he terrorized and traumatized other children. This is a man that was capable of beating a woman halfway to death in front of children, in front of his own children. That's dangerous. Whether Daisy acted afraid of it or not doesn't change what he did. Whether Daisy made a flippant remark or made fun of him or insulted him doesn't change what he did. The state wants you to ignore and forget that he did that. Well, they can ask you to forget whatever, but you know what happened. This order Paragraph 3 of this order, Exhibit F, the minor children, Pedro Jimenez and Mia Jimenez, shall remain in the legal and physical custody of the mother, whose name is Daisy Link. Next paragraph, the non-custodial parent of Pedro Jimenez and Mia Jimenez is Pedro Jimenez. And then further down, Pedro Jimenez has not substantially complied with his case plan. A brief description of this plan is as follows: substance abuse treatment, assessment, individual therapy, parenting, domestic violence. He didn't do it then. He wasn't going to do it in 2022. Quite frankly, it's clear that he was never going to do it. He was less concerned with getting back his kids and having more time with his kids. He was more concerned with getting high and beating up Daisy Link. State will tell you that Pedro was broken, that Daisy did all these horrible things to you. They completely ignore what he did to her. And you can't ignore that because that goes to her state of mind. That goes to her state of mind right when she pulled the trigger. Yes, she went to pick him up. And I'll submit to you, that was a bad choice on her part. But you know what? relationships are complicated. When two people love each other, even if it changes, it's complicated. When you add children to the mix, it's complicated. When you add property to the mix, it gets more complicated. When you add the fact that these kids, even though their dad's not a good guy, they love their dad. She knows that. So yes, she doesn't want to get him arrested. She doesn't want to get him deported. She doesn't want to do that. She just doesn't want to be with him anymore, and that's her right. And why would she want to be with him? He beats her up. He did so for almost the entire course of their relationship. And you need look no further than this order to know that. The state went on to say that Daisy Link picked up the casing, the spent casing in this case. There's no evidence of that, ladies and gentlemen. None whatsoever. They can say it till they're blue in the face. They have to prove it. It's their burden. And if they haven't proved it, which they haven't, then you can't accept it because it hasn't been proven. There's no evidence that she picked up any casing whatsoever. She was with police for almost an entire day from the point they got there at 3-something in the morning till she got to the station several hours later, till she started her 11-hour-long interrogation at 9? So she was done, the following evening? That's almost 24 hours. They had eyes on her the whole time. But they want you to believe that she found this casing and she got rid of it. Well, that doesn't jive with the evidence. There's no evidence of it. She told them where the gun was. She called 911. She tried to help this man as soon as she found him. And the only reason she didn't call 911 sooner is because Pedro stole her phone. The state said that the officers were kind to her. Are you kidding me? No, they weren't. They say that she threw a chair at Detective Morales. No, she didn't. There's no evidence of that. None whatsoever. There's 100 officers on there. All of them have body cams. Have you seen a single body cam of her throwing a chair at anybody? No, because she didn't. The state talked about Pedro Jr. They said one thing, and this is the other thing that I would agree with, that Pedro Jr. is a very smart boy. I agree, he is a very smart boy. Kids are honest. Yes, they are honest. And I would submit to you, Pedro Jr. was honest in his testimony. I specifically asked him, and he specifically said, I'm not telling you, nobody told me what to say. This is what I remember. Has he spoken to his grandmother in the last 3 years? Yes, because he lives with her. What's he supposed to do? What's he supposed to do? Because he speaks to his grandmother, therefore you shouldn't believe a word he says? You can judge that boy's credibility on your own. We have footage in this case which was deleted. It was lost while it was in police custody. The police only viewed one snippet, which is when Daisy Link went to Pedro while he was lying there. They didn't bother to look at anything else. They didn't bother to look at any other footage when he stole her purse or when he was running back and forth the 3, 4, 5 times that he was running back and forth, that Daisy's mother told him to leave, that Daisy told him to leave, or they threatened to call the police. There's none of that. It would have been on there, but they lost it. Nobody knows how. Everybody's saying, wasn't me, I don't know, we did everything. It must have been the machine. It wasn't the machine. They gave the machine back to the owner. It worked fine. The only difference is a month's worth of footage is gone. I didn't delete it. The police did. The police lost it. The police destroyed it. What does that mean? They have it in their control and they lose it. That is incompetence of the highest order. This is a murder case. That is incompetence, ladies and gentlemen. You should consider that. We have a blood trail here, which begins begins in front of the house. The state will have you believe that at the time Pedro was shot, he was running away. He wasn't running away. He was running to the house. He was going to barricade himself inside that house where those kids were. He was going to keep her out, and he was going to do God knows what. I say God knows what because we already know what he did 5 days before. We already know that he snorted about a mountain of cocaine shortly before this happened. That was her home, which she has a right to defend. Pedro did not have an invitation or a right to be in that home. He made it clear that he was going to break into that home and lock her out and keep her away from her children, which he had no right to do. And importantly, she has every right to use deadly force to prevent him from doing that. And this is not just me talking. This is the law. This is the law, which I'm going to read to you in a moment. The law, I will remind you, that each and every one of you swore an oath to follow. Was Daisy honest with the police from the get-go? No, she wasn't. Okay? No, she wasn't. Should she have been? Probably. But can someone really understand what's going through somebody's mind when they're in that position? I think we can all agree that what happened to Daisy Link in the 5 days leading up to this incident was extraordinarily traumatic. Unless you've been through it, it's hard to imagine what that's like. I would say it's almost impossible to imagine what that's like unless you've actually experienced it. It's very easy to second guess and judge somebody for their actions when you don't know what was in their mind at the time they made it, ladies and gentlemen. As I told you before, relationships are complicated. How common is it to see a couple who clearly are wrong for each other, who clearly shouldn't be together, but for whatever reason, they keep coming back to each other. They keep interacting. Maybe they separate, maybe they come back, maybe they go back. It happens. Well, that's because these things are complicated. There are children involved. There's a history involved. There's a familiarity involved. And yes, there's love involved. And that makes it very difficult. So it's very easy for us to say, you should have left. You shouldn't have called him back. You shouldn't have gone to pick him up. You should have called the police. You should have had him deported. Should have done all these things. I agree. She should have done all those things. They should have called the police. They should have done all these things differently. She didn't want to. Daisy told you why. Again, this is a court order. This court order says Pedro gets to see those kids once in person, see them in person once a month with the supervision of his mother. Daisy had a fear, a reasonable fear, that if the court found out that she was allowing Pedro to see those kids in person, knowing that he's still being violent, knowing that he's still abusing drugs, a court could very easily and theoretically say, you know what, you're not supposed to have him around those kids. You know what he's doing. We're going to take those kids away from you. As a parent, is there anything scarier? Anything scarier than losing your kids? I don't think so. If you can think of something, I'd love to hear it. I can't think of anything. I'd rather be killed than lose my kids, personally. She feels the same way. That's why she did what she did. You can disagree with it. You can not like it. That's fine. That's your right. But that doesn't change the fact that at the time she pulled the trigger, she had every right to do so. This paper that you all have, jury instructions, this is the only law that applies in this case. There is no other law, no other instructions that apply to this case. You are to decide your verdict based on these instructions and these instructions alone. Okay? So let's go through the instructions. Page 3. This is really loud. Sorry, I can't. The best I can do, I'm sorry. Page 3. You all have it, so that helps. Justifiable homicide. Use of deadly force is justifiable if done while resisting an attempt to murder or commit a felony upon the defendant, in or upon any dwelling house which the defendant was at the time of the killing. Miss Link was at her home. She had every right to be there. Mr. Jimenez had no right to be there. I don't care if his kids were there. He had no right to be there. He had no right to see them. You saw the order. He did not live there. He did not have the keys. He was not on the lease. The address was not on his license. You've heard testimony from multiple people that he did not live there. You have not heard testimony from a single witness that said he lives there. They want you to believe he lives there because it's convenient for their case. They don't want you to believe that he didn't live there, which he didn't, because they know that if you know he didn't live there, they're done. Their case is over, and I'll explain that to you in a second. So the question is, has the state proven to you beyond a reasonable doubt that Pedro Jimenez lived in that house? No, they haven't. At best, maybe you can all say, yeah, I'm not sure. Maybe he did, maybe he didn't. What are they pointing to prove that he lived there? Because there are some shoes and some shirts that appear to be for males in the house? Does that prove he lived there? I'm sorry, it doesn't. And use your common sense, people, okay? I still have stuff at my old house, and I've been divorced for 10 years. It's still there. It's not my house. I don't live there. I don't have the key. I can't go there and come and go as I please. No, I have to knock on the door. I have to be allowed inside like everybody else. Was that my house before? Sure. It's not anymore. Do I still pay the mortgage? Yeah, I do, actually. But I still don't have a right to go in there because it's not my house anymore. That was not Pedro's house. And unless they prove that it was his house and that he lived there beyond a reasonable doubt, then no. Then as far as you're concerned, that was not his house. He didn't live there. He did not have a right to be there. Same page, page 3, excusable homicide. The killing of a human being is excusable and therefore lawful. The killing is lawful, which means it's not illegal. It is lawful, not a crime. Under any one of these following circumstances, when the killing is committed by accident or misfortune, and doing any lawful act by any lawful means in the ordinary caution, okay? Number 2, when the killing occurs by accident and misfortune in the heat of passion, upon sudden and specific provocation. Can you see how that scenario could apply to this case? He's been asked to leave multiple times. You heard testimony from Daisy Link. Before she got the gun and fired, Mr. Jimenez grabbed her by her hair and threw her. And in grabbing her by her hair, he opened up the wounds that he created just days before, and he threw her to the ground. She's already told him to leave. She grabbed the gun. She told him, leave. And you heard what he said. I'm not leaving. I want to die. I'm ready to die. And then he ran to go break into the house. Then she fired. And then, and only then, when she fired, that's when he started running away. It took the shot, it took her firing the gun for him to abandon his intention to break into her house. And if you are stopping somebody from breaking into your house, that is justifiable use of deadly force. And it was going to happen imminently. We know that. We saw the blood trail. We heard the testimony. He was going to break into her house. She did everything she could to stop him. He refused. So she fired the gun. And it worked, because when she fired the gun, he ran off to the alley. I want to talk about the instruction for second-degree murder. This is on page 4. You can see it there. Three elements that the state has to prove beyond a reasonable doubt in order for you to be able to convict Daisy Link. And this is what your case is going to come down to. Number 2, the death was caused by the criminal act of the defendant. And number 3, there was an unlawful killing. So, I highlighted the relevant portions in 2 and 3, just to give you all a little guidance there. So, in order for you to convict her of anything, whether it's murder or manslaughter, of anything, you have to find that her firing that gun was a criminal act and that her killing Pedro was unlawful. So, in other words, what your deliberations are going to come down to is whether or not this killing was justified or not. Was Daisy justified in using deadly force or not? That's it. That's the decision you have to make, and that's going to be how you reach your verdict, okay? It says it right there. So, let's fast forward here. This is the key instruction in this case, ladies and gentlemen, page 8. It's the longest instruction out of all of them. It's, oh boy, look at that. It's 3 pages. It's 3 pages long. So, sorry, but we need to go. Justifiable use of deadly force. 3rd paragraph, okay? Defendant does not have the burden of proving that she was justified in using deadly force. Instead, for you to find her guilty, the state must prove beyond a reasonable doubt that she was not justified. This is what I said earlier. I don't have to prove that she was justified. It's the other way around. They have to prove she was not justified. So have they proven that she's not justified? Have they proven it beyond all reasonable doubt? Well, let's see. Let's have a look. Keep reading. The law on justifiable use of deadly force is as follows. Defendant is justified in using deadly force if she reasonably believed that such force was necessary to prevent the following: imminent death of great bodily harm to herself or another. So if she believes that imminently means it's about to happen, it's going to happen any moment now, that she's going to get hurt or another person's going to get hurt, you have the right to use deadly force in that instance, okay? And then there's another option, or B, the imminent commission of burglary or false imprisonment against herself or another. At the time that she shot, Pedro Jimenez was running to break into her house, to barricade her out of her house. Okay? He had no right to be there. When you enter somebody's house without permission, that's burglary. I'm going to read you the definition of burglary in a moment. So that's number 1. That's one felony that he was about to commit, which, according to this instruction, If she knows that he's about to commit a burglary upon her house, she has the right to shoot him, to stop him. This is the law that you are required to follow. In addition to burglary, false imprisonment. There are 2 kids in that house. Those kids are in her custody, not in Pedro's custody, her custody. By barricading himself inside the house, Pedro would be illegally separating those kids by force from their mother, without permission, without authority, without any right to do so. She has a right to use deadly force if she has reason to believe that that's about to happen. And we all know that that was about to happen. He was about to burglarize her home. He was about to lock her out of her home and commit false imprisonment upon her kids. So moving on to the next part. This long paragraph here, right here on page 4, on page 8, this paragraph has to do with whether or not Daisy Link had a duty to retreat or not a duty to retreat. You can go through that and read it to yourself, but ladies and gentlemen, as you will see in a moment, she had no duty to retreat because she had every right to be there because that was her home. On the other hand, Pedro Jimenez had no right to be there because that was not his home. He had been told repeatedly to leave. He had been threatened that they would call the police. And he did leave, but he kept coming back. Multiple times, he kept coming back, kept terrorizing this woman. She did it while her mother was there, and then he did it again after his mother left. His mother left at 1:32 in the morning, and he still came back after that. He's terrorizing her at 3 o'clock, 3 something in the morning. I'm going to refer you to page 8 at the bottom right here. If the defendant was in a dwelling or residence in which she had a right to be, which she did, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent death or great bodily harm to herself or another, or the imminent commission of a burglary or a false imprisonment against herself or another. So again, this says, again, if she has reason to believe, well, first of all, it says if she's in a place where she has a right to be, there's no question she had every right to be there. That was her home. If she's in a place where she has a right to be, she can use deadly force to stop somebody from burglarizing her home and to stop somebody from keeping her outside of the home and keeping her away from her kids who are inside the home. She had a right to use deadly force in each of those and in both of those. This is the law that you are required to follow. After this defines the crimes of burglary and false imprisonment. These are the 2 crimes that I would submit to you. The evidence has clearly demonstrated Pedro Jimenez was intent on doing and was in the process of doing, and the only reason he stopped from doing it is because she fired that shot. That was the only way that she was going to stop him from doing that, and we know that from Pedro Jimenez himself. I'm ready to die. What does that mean? I'm going to do what I want. You want to stop me? You're going to have to kill me. You're going to have to kill me. Burglary. Entering a dwelling owned by or in the possession of another, and at the time of entering the dwelling, the unauthorized person had the intent to commit the crime of false imprisonment. Please tell me, how has the state disproven that this was about to happen? Can you honestly say to me that the state has convinced you beyond all reasonable doubt that Pedro Jimenez was not in the process of rushing in to barricade himself inside that house and lock Daisy Link out? Have they disproven that beyond a reasonable doubt? If the answer is no, then your verdict is not guilty. If the answer is yes, then okay, then I would ask you to ask yourself, how have they proven it? What have they shown you? What have they introduced to prove that? I would submit to you they've introduced nothing. Nothing to disprove that that man was going to do that. Certainly not beyond a reasonable doubt. That's burglary. False imprisonment. That's the next one. We're still on page 9. It's right here. False imprisonment is defined as follows: to forcibly or secretly confine or abduct another person without lawful authority to do so. Forcibly would apply here. He was attempting to forcibly confine those kids within that house and keep the mother out of the house. The next paragraph defines secretly. You're free to read that as much as you want, but secretly doesn't apply here, so I'm not concerned with that. The next paragraph is very important. Very important. Confinement of a child under the age of 13 is against the child's will if such confinement is without the consent of the child's parent or legal guardian. In other words, if you're locking two kids inside a house against the will of those kids' legal guardian, and those kids are under the age of 13, which, as you already know, those kids were ages 7 and 5 at the time, then that's false imprisonment. We know that Pedro was not their legal guardian because that's what this order says. So unless the state is going to come up here and find a way to invalidate this court order, which if they have a way to do that, I'd love to hear it. They're not going to. This is a court order. This is a valid court order. And this court order was in place in full force on that night. Daisy Link asked him to leave. He did not respect her request to leave. He was going to commit false imprisonment. And that is what this instruction tells you. I'm going to keep reading. Please bear with me. But again, this is a long instruction, but it is the most important instruction in this case, because this is what your deliberations are going to come down to. In deciding whether the defendant was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. I'll say that again. The danger need not have been actual. So it's actually legal to use deadly force against somebody, even if there's no real danger. The key is whether the person using the force reasonably believed that the danger was there. Now, I would submit to you, there's no question that the danger was real. There's no question that the danger was imminent. But this instruction shows you that even in cases where there's no real danger, if you find that the person who used deadly force had reason to believe that there was a danger, that's enough. That's enough to say that the use of deadly force was justified and lawful. I'll keep reading. To justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Pedro told her, "You're going to have to kill me. I'm ready to die." What else was she supposed to believe? What else was she supposed to believe? She didn't put herself in that situation. He put her in that situation. The state will tell you, oh no, she brought him to the house, so it's her fault. No, she brought him to the house. She knew she was going to leave. First of all, she was supposed to pick him up and take him to his mother's house, but she explained to you she came back because he still had his keys. She wanted him to see the kids. She wanted to make it work so that she could get away from this man finally, move away from him, not have to deal with him beating her up. And she was implementing her plan. Whether it was a good plan or not, that's up to you to decide. But that was her plan. That's what you heard. It has not been refuted by the state in any way, shape, or form. She went to pick him up. She came over. She came over while her mother was there, and you heard from her mother and you heard from her. He was obviously high on cocaine because he used a bunch of cocaine at his friend's house. He bought a bunch of cocaine from his friend. He was drinking. You heard what was in his system when he died. He was extremely under the influence of a ridiculous amount of cocaine. He was drunk. He was out of control. She brought him back, and as soon as he started becoming violent, which he did on multiple occasions, as you heard from her mother and from her, as soon as that happened, he was told to leave. He was told, 5 different times to leave? And 5 different times he left. 5 different times he came back. You saw video of him running around. There's a video of him being told to leave a few hours before he was shot. How many times does this woman have to tell him to leave? Once is enough. Once is all it takes. It's my house. You need to leave. You need to leave. If you don't leave, you're committing a crime by not leaving, okay? You're committing a crime. But he knew that she didn't want to call the police on him. He knew that for whatever reason, and she shouldn't have, but for whatever reason, unfortunately, she had a soft spot for this man, and she kept giving him opportunity after opportunity, even though, as we all know, she probably shouldn't have. But again, relationships are complicated, and you can judge her all you want. You can disagree with her all you want, but you don't know what it was like for her. And that's the decision she made. And it's understandable because, again, relationships are complicated. And that's the position that she was in. But she didn't create this position. She asked him to leave. He put her in that position by coming back repeatedly. I'm at the bottom of page 9. The defendant is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another when using defensive force that was intended or likely to cause death or great bodily harm to another, if, this is important, A, the person against whom the defensive force was used was in the process of unlawfully and forcefully entering or had unlawfully and forcefully entered a dwelling, residence, or occupied vehicle. This is black and white. There's no room for interpretation here. You are presumed to be in reasonable fear and justified to use deadly force if somebody is in the process of unlawfully and forcefully entering your home. That is exactly what he was doing. And unless they can prove to you beyond all reasonable doubt that that's not what he was doing, then your verdict is not guilty. Anything other than that would be a disgrace. And I know you all don't want to make a disgrace here. I think you all want to get it right. There's only one right answer here, okay? I'm confident that you're going to get the right answer. I want to go to the next page. The next paragraph B, defendant knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring. This goes hand in hand with the previous one. Reason to believe it was occurring. He told her he was going to do it. He told her, you're going to have to kill me. And she saw him doing it. And the blood trail, which begins in front of that front door, corroborates what she told you. The state has given you nothing to dispute or disprove that. The next paragraph, this is page 10, right over here. The very next paragraph talks about situations where the presumption of reasonable fear does not apply. Okay? So if any of these examples, there's 4 examples, if any of them were to apply, then you could come to the conclusion that, okay, well, then this person didn't have a reasonable reason to believe that she was in danger of something bad happening to her. I'm going to start with the last one, with D, because this one's easy. The person against whom the defensive force is used is law enforcement. Well, Pedro Jimenez is not a law enforcement official, so we know D doesn't apply. So you can scratch out D. D is useless to you, okay? C, the person who uses defensive force is engaged in a criminal activity or is using the residence to further a criminal activity. This doesn't apply either. Daisy was not using her home to conduct a criminal activity, and she was not committing a crime when she was just at home in her front yard, minding her own business. So C does not apply. You can disregard C. B, the person or persons sought to be removed is a child or grandchild. Pedro Jimenez is a grown man. He's a grown man who's 6'4" and weighs 250 or 60 pounds, and he could easily beat the crap out of Daisy whenever he wants, and he has on multiple occasions. So B doesn't apply. So all that's left is A. So let's read A. The person against whom the defensive force is used has the right to be or is a lawful resident of the residence, such as an owner, lessee, or title holder. Has the state proven to you, beyond a reasonable doubt, that Pedro is a lawful resident, owner, lessee, or title holder? No. They got up here and they told you over and over it was his home. He lived there. They were a family. They can say it till they're blue in the face. They have to prove it. Have they proven it? No. The only proof you've received on that topic is that it wasn't his home. You have lease agreements that he's not on. You have his license that he's not on. You have testimony showing that the locks were changed. You have testimony that he lived at his mother's house. Would he go over there to see the kids? Yes, but that doesn't mean that he lived there. All the evidence that you've heard proves that he did not live there. At best, you can say, well, maybe he did, maybe he didn't. But if that's your conclusion, then it has not been proven beyond a reasonable doubt. And again, the state has to prove their case beyond a reasonable doubt. They have not done so. I want to focus on this paragraph, which is right after A, B, C, and D. A person who unlawfully and by force enters or attempts to enter another's residence is presumed to be doing so with the intent to commit an unlawful act involving force or violence. The fact that he was forcing his way into her house, according to this instruction, allows you to presume that he was doing so with the intent of committing a violent act and committing a crime, which is exactly what gives Daisy Link the right to use deadly force. And finally, and this is important, it's all important, but last paragraph, if you find that the defendant, who because of prior threats or difficulties with Pedro Jimenez had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Pedro Jimenez, you may consider that fact in determining whether her actions were those of a reasonable person. They had prior difficulties. You know all about them. Isn't it reasonable for Daisy Link to fear that this man could hurt her, to fear that this man could kill her when he just did this to her a few days before? Yes, you can judge her for communicating with him and spending time with him in the intervening days. But as she said, number one, she loved him. That clouded her judgment. Number two, when he wasn't on drugs, there was no problem. The problem was when he was on drugs. And we know, without question, he was on a lot of drugs when she shot him. And what did she say? When he's on drugs, when he's on cocaine, he's a monster. And that's what he is. That's what he is. Finally, ladies and gentlemen, at the beginning, top of page 11, in considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capacities of the defendant and Pedro Jimenez. Pedro Jimenez is a man, Daisy Link is a woman. Daisy Link's not a petite woman, she's a larger woman, but Pedro Jimenez was a lot bigger than her, a lot stronger than her, a lot more dangerous than her, and he's proven that he could hurt her, and he did hurt her over and over and over again. You may not like her, you may disagree with her, you may think whatever you want to think. You may take exception to what she said on that video. You may do all that. But none of that changes the fact that at the time she fired that shot, that man was going to barricade himself inside that house. And according to the law, which you all swore you would follow, she was justified in using deadly force.
Circumstance.
We stop the clock for this look here then. Yeah. This is the next of this shot. Wait. Walking the lines, do something in the so walk the line, walk the line, thinking about how he's going to terrorize Daisy next, which she's been doing all day. He's been told to do it 5 times. He's back again. You think he's back again for a good reason? You think he's back again to do something nice? You think he's back again to make up? No, he's back again to cause trouble. That sound like somebody who's in fear? No, that sounds like somebody who's coked out of his mind, somebody who likes to beat women up, somebody who likes to terrorize women.
She shouldn't have. If that's true, despite the fact that on her phone, those videos conveniently.
Whoa, hold on. Something just happened. They just switched from defense to state. So hold on. Maybe they froze. Let me just rewind that a little bit. They just literally just switched from the defense to the state. Okay, that was weird. Let me back it up a little bit.
Okay. You may take exception to what she said on that video. You may do all that. But none of that changes the fact that at the time she fired that shot, that man was going to barricade himself inside that house. And according to the law, which you all swore you would follow, she was justified in using deadly force. We stop the clock for this look here then. Yeah. This is the actually of this shot. Wait a minute. One of the lines, do something in the so walk the line, walk the line, Anderson. Thinking about how he's going to terrorize Daisy next. And she's been doing all day. He's been told to do the 5 times. He's back again. You think he's back again for a good reason? You think he's back again to do something nice? You think he's back again to make up? No, he's back again to cause trouble. That sound like somebody who's in fear? No, that sounds like somebody who's coked out of his mind, somebody who likes to beat women up, somebody who likes to terrorize women, and somebody who's going to break into his ex-girlfriend's house because he can. Daisy Link is not guilty. Find her not guilty, please. Thank you.
Thank you. All right, state the report.
I'm just gonna judge it.
Yeah, it's.
Proceed.
Yes.
Thank you. Ladies and gentlemen of the jury, this is the last time I'm going to talk to you. I'm sure you're as sick of my voice as I am at this point. So I'm not going to take up too much of your time, but there's a couple of points that I want to touch on about what defense just mentioned. He said that the officers were rude, disrespectful, and mean. That's actually not what Daisy said yesterday on the stand. She even mentioned that they let her go to the bathroom at her house. They spoke to her. She even said to Officer Edwards, nobody would have done this to him. I don't know who would. Except on cross-examination, what she said was, I shouldn't have, because she knew she had other options. She knew if we take her at her word, and I think we can all agree there is absolutely zero reason to take her at her word at this point, lie after lie after lie. This happened 5 days ago. She said she spoke to the police. Maybe, maybe not. Lie after lie after lie. She shouldn't have. If that's true, despite the fact that on her phone, those videos conveniently aren't there, call the cops, tell them. Let them know. Take your kids and flee. Your kids, your children, your 8-year-old and your 5-year-old, take them. Get them away from that dangerous man. That's what she wants you to believe. Instead, though, what does she do? According to her, he leaves. She goes in her car, goes back home, takes a nap. Day later, day after that, Pedro comes over. They sleep together. They mentioned that I mentioned on my closing argument that I said that the defendant was upset that the victim wasn't home. And they said that's not true. There's no evidence of that. That's actually not true. She says at some point in her statement, I don't have the timestamp, but she says in her statement, it's not fair. I told my mom it's not fair. He's always on the run. He's never home. She says directly to the officers, it's not fair. I'm upset. Almost beaten to death. These are horrible. Horrible. But as we heard, Daisy admitted she herself is an abuser. These are horrible, but these happened 5 days before. Was it going through her mind when she invited him over the day after or the day after that? Was it going through her mind when she picked him up from a friend's house? It wasn't. She had forgotten about this. She even said it on the stand yesterday. How do we know it was their home? Well, ladies and gentlemen of the jury, Daisy Link told us it was yesterday. She said Pedro never had a key, except on cross, she said, well, actually, he may have. When he left, he probably had a key to my house. They lived together. How do we know? Well, here's the thing. On Pedro's address, it has on his license, it has a certain address on it. But what else? It has that address on it. Mail that was found in a car with Daisy Link's name on it as well. They lived together. But you don't have to take the evidence like that. Pedro Jr. said the same thing. He said, my dad lives in my car, or his car, because he's a trucker. He's never home. Except when he's home. He lives here. He sleeps on the couch sometimes, sure. But this is his home. He said that as much. The court order, I'm sorry, the court order, this is what they thought of it. They thought it was trash. That's what they did with it. They threw it on the ground. They didn't care about it. How do we know that? It's on video. She's giving him more than what this says. This, to them, was trash. There is no termination of parental rights. They ignored it over and over and over again. The pistol whipping episode from 5 days ago, if you take her at her word, and you shouldn't, there is no reason to take Daisy Link at her word. But if you take her at her word, it happened 5 days before. And then they slept together. And then she picked him up. And the interesting thing there about picking him up from the friend's house is she says it's a drug den. There's prostitutes, there's drugs throughout. He's a monster on drugs. Well, we have it on video of them actually arriving back from that house. You tell me if that looks like an angry, aggressive man playing with his children. Apparently high on cocaine, according to Daisy at that point. A monster is what she said. Except she let that monster hang around her children. Play with them. Be around the house. The video that was destroyed, it wasn't some cover-up. It wasn't a conspiracy. They actually explained explicitly how. Sergeant Fernandez came in and explained she was called out on scene, plugged in a hard drive. It wasn't working. So what they do? They have to take it back to headquarters. There is a specific program that they use. And she explained, if they run that program on that hard drive, plug it back in, it will delete everything. It will reset the hard drive. And so what do? They attempt and attempt and attempt to get that video, but they can't. And they give up. And so they return it back to the homeowner, who then puts it back in. It's an old hard drive. It got reset. And finally, ladies and gentlemen, Daisy Link's story doesn't make any sense. And the reason it doesn't make any sense is because of the gunshot and how it traveled. Because what she says is he was charging at me and I fired. The only way this gunshot, this trajectory makes any sense at all is if he is running away. That upward trajectory through the foot, in the neck, through the thigh, in and out, mean is dead. Is it his back is turned and he is actually running away? Otherwise, you'd have an injury that way, to the front of his body. That's not what happened here.
30 more seconds.
We know what happened here. We know that Daisy Link purposely discharged that firearm at Pedro Jimenez as he fled her. The state has proven beyond a reasonable doubt that she is guilty of second-degree murder, and you should find her guilty as such. Thank you.
Okay. On page 19. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when you all have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any other person outside the jury room about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during the deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given you in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices at your seats where they will be guarded by the bailiff while you deliberate. You can send a note or a phone call to your loved ones, letting them know you're deliberating before Umberto takes those electronic devices. If you need to communicate with me, so from this point on, if you're going to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the lawyers before I answer. So it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. If there's something missing, send a note, or we'll try to communicate with you if there's anything that we needed to keep back with us. If you need extra copies of anything, such as the transcripts, let us know. I can make 6 copies for you all. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we share. You can keep those copies with you. One of them has to be signed and submitted to me, by me to the clerk. I have 3 jurors, so I know that you all have been very dedicated. We can hear you laughing, so I think you all have become close since then. That's a good thing. But there's 3 dedicated jurors that will be leaving us. So you're going to go with Umberto up to my office. We have lunch for you. I'll shake your hand and thank you. It is Grace Rivas, Liseth del Carmen Meza, and Crystal Martinez. So just keep all your stuff with you. Follow Umberto and Lisette up to the 4th floor. And then you all can go into the jury room now.
All right, the jury.
If you want, take your time, send the message. Umberto will collect your electronic devices. Thank you. All right, Joseph left. Lawyers, please take a look at the exhibits. If there's a clean laptop, I'd like to send that back.
Yes.
Judge, can I just run to Dillo's quote real quick?
Oh, sure.
I'll clean up my mess.
All right, we can go off record when Mr. Thomas comes back. We'll discuss the exhibits. Okay.
All right, let's get a poll going. How long will they take? Let's start a poll. Yeah, three women, all Hispanic, Rivas, Martinez, and I didn't catch the last one, but then they show them walking out. Oy. Well, this camera, they can't move. This camera is fixed. All right. All right, so they're starting at 2:08, let's say. I'll say 2:05 just for keep it simple. So 2:05 they start. 2:05 they're starting. All right, let's see. How long will the jury deliberate today? So today only, 0 to 2 hours, which will get us to, actually, that's going to get us to 4. I'll do 0 to 1 hours because I think they're going to go home. I'll do 1 to 2. Well, yeah, 1 to 2, 2 to 3 hours, which would get us to 5, and then we'll do 3 to 5 hours. Let's just do that because that'll get us 5 hours would get us to 7. I don't think they're going to last past 7, but we'll see. We'll see. All right. So new poll. New poll. That's just today now. This is just for today, not in general, or this is just for today. This is just for today. Let me see if yeah, so that's it. They're not going to leave that on for us. All right. What should we watch? What time is it here? It is 2:10. Oh, it came back. Good. Came back. It's 2:10. 2:10. So this court goes to 5:30. So it's 2:10. So to 5:30 would be like another 3 hours, 3 hours, 20 minutes or so. So about 3 hours before the courthouse is closed. But I don't know if they're going to go longer. But they've been going from 10:30 to 5:30 every day. So they've been going 10:30 to 5:30 every day. Usually ending early. Actually, they usually end early. No, we're not going to. I don't like to do that, Northwest. I don't want to cross-pollinate. I'm not going to cross-pollinate. I want to stay on this trial. But what we can do is we can show some more. How about the body cam? Let's watch that body cam again. And the ring. Let's watch the ring. Oh, you know what? First and foremost, let me pull in Joe. Joe Schmo sent us a email. Hold on. I want to read this email that Joe sent. All right, so as you guys know, Joe is heavily involved with the London Valdez trial. And if you guys could go support him, let me find this email. Okay, so he sent out this email. My dearest friends, I'm deeply invested in this story of London Valdez. I would greatly appreciate any eyes that you can help me put on this story. London, a 16-year-old beautiful teenager, went missing on June 5th, 2025. She was reported missing on June 7th and eventually as a runaway. She was last seen with 2 adult males with criminal histories, but her body was not found until June 12th. So 7 days. There are questions about the 2 adult males, and there are questions why her body wasn't found for 5 days after she was reported missing, and 3 days after the adult males admitted having seen her last. It's a tragic story that demands answers. The OSBI, which is Oklahoma State, and DA are on the hook now, and the more pressure that we can put on them, the better chance that the family has for answers. I've put together some shorter clips. I can put together more from my live stream if that would be helpful. So if you guys don't know Joe Schmo 88, to go check him out and support his, I guess, quest. Has it become a quest now, Joe? Joe's quest to get justice for London Valdez from Oklahoma. So that's we're gonna try and help Joe get some justice for London Valdez, only 16 years old. He's done a couple interviews with the mom, I think with the grandmother. So if you guys can go support Joe Schmo, please do so. All right. Hold on. Let's see. All right. I think it was day 65. Hold on a sec. Trying to find the body cam again. All right. We played this before, and I think we got a ding, but I think ultimately they were okay with it. Hold on. Meeting with YouTube. I just want to make sure before I do that. Let me just check. Let me just check with my producer. Check with the... Okay. All right. So we're going to play this. We're going to play this body cam again. All right, it is graphic. I know you guys have seen this before. We're going to put this down here. We're going to put that down there. I'm going to put that over here. All right, so we have our little watch window there. All right, so we watched this the other day, but I want to watch this again. Remember, he's 6'4", like 240. We were wondering about the tourniquet. She says she took off his shirt and used that as a tourniquet. So let's check this out again. And it is graphic, just so you guys know. YouTube dings us, but Aaron, refutes it, and they seem to be okay with that. So, all right. So this is body cam from obviously the night of. Plus, it also shows the alleyway. They were talking a lot about the alleyway and all that. So I hope this helps you guys understand a little bit more too.
All units correct. 47, myself, 54 and 41 row.
Don't move! Do not move!
Units arrival at 327, all units correct.
Hey, what's going on, man? I see a hole from the back and a hole from the front. He was shot in his head. I took off his shirt. Is he related to you? No, he's actually my husband. Oh, okay. Where is it at? Right here, right here. And you can see Alice from the front. You can see the hole from the front. Hey, just stay right there, boss. Are you okay? Hello? Stay with me.
439.
It appears to be a GSW. He has a gunshot wound. It's going to be into the right leg, into the right thigh, and out the right thigh. No, hey, just stay down, there, boss. Stay down, hey, lay on your back, please. Hey, stay on your back. Stay down.
All units correct.
Stay down. Go in my trunk, grab right there's my trauma kit. Grab me gauze and all that. Pedro, what the happened? Pedro. Where's the ambulance? They're coming, Mama. They're coming. Look, there's a lot of blood there. Open it up. I got my hands are dirty, bro. Grab me too. There's more. Check and see if there's anything else. We're gonna have to cut off this stuff. Just cut it off. Do what you gotta do. Just sit down, bro. My hands.
439 is fire arrival.
What's the best way for fire to come through? Hey, are you okay? Pedro. Hey. Hello. I don't see you. I'm in the alleyway. Did you hit a major artery?
Somehow get you anything. All units correct.
Pedro. Hello. Pedro, stay with me. Hello. Look at me. Pedro. Hello. Look at me. Are you here? Are you with me? Pedro. Hey, boss. Oh my God. Let me see, Mama. No. He's alright. He's still. Pedro. No. Hey. Mama, I need you to relax. I need you to calm down. Give me a second. No. Pedro. Hey, put pressure on that. Edwards, put pressure. Hey. Pedro. What the is happening? They're coming. Hey, I need you to calm down, Mama. I need you to calm down. Pedro. What's the GSW at? Right there in the top. Pedro. Hey, no, hey, look at me, please.
439 ET.
Pedro, please. No, Pedro, hey, look at me, please. Pedro, I need you to get up. Pedro, please.
Shallow breathing at 330. All units correct.
Where the is the ambulance? They're coming, ma'am. They're coming. Hey, stay with me, please. Pedro, please. Pedro, please, stay with me. Oh my God. No. Pedro, please. Don't.
447.
Hey.
All units correct.
No. Ma'am, I need you to back up, please. Back up, please. Pedro. Still got pull. I hear fire. Yeah, fire arrival. Where are they? Sounds like on 15th Street. Is he
You okay? Is there a pulse? No! No! No!
Pedro!
Pedro, please!
Ma'am, I need you to back up. Pedro! Pedro! Don't give up, buddy.
No, please, don't let him go, please! What the
Ma'am, I need you to back up.
447 was that fire arrest?
Please don't let him go, please!
Back up, please. Pedro!
447, I can't read you.
Just tell them we were starting CPR. Got a pulse?
For CPR, Roger.
Hey, did rescue see where we're at? I heard the truck.
We have an ETA on rescue?
No, I heard the truck. The truck should be on that side.
Yeah, started.
Try to run up to them and guide them in here. Pedro! Pedro! Come on, Pedro.
Is he breathing?
Stay with me. Yeah, relax. There you go, Pedro. Come on.
Don't give up, Pedro. You got this, bro.
Come on, boy. Hey. Pedro. Pedro.
454 for fire, they're showing arrival.
Pedro.
Please, I'm waiting right now. Kids on fire arrival, the mail at 333, is correct?
Is he?
Pedro.
Do you have
Ma'am,
a
I need you to back up, please.
Do you have a pulse?
Yes, relax. Back up.
I need you to relax. You need, look, come over here.
Pedro. Hey, boss. Need you to tell me what happened. Pedro.
Who did this to you, bro?
Come on, Pedro. Pedro. Hey.
Pedro, please!
Pedro. Pedro.
No, does he have a pulse? Where the is rescue? Where the is rescue?
Hey, he's got a weak pulse. GSW to the right thigh. It looks like a through and through.
What's
You guys got a ticket?
No, I didn't. On that girl, he left about 45 minutes ago. My house. I live down the street. But you can hear him wailing.
We got a trail going. I still got to follow up.
Where's it lead?
I can hear him.
Which way?
Twice. I came. Finally. No, I didn't see him. I was walking. I saw him laying there.
There's a pretty large blood test. If you got other units response.
Yeah, she found him here.
Like laying here like this?
Yeah. When I got here, this is where he was.
I got no pulse. Edwards, I'm gonna follow it down. Okay.
433, 423. 433, that's all. Both units arrival, 33, 16. 447. They're in the alleyway that runs in the large blood trail in the cavity area. 23 reference. Units are started moving off the area just in case.
Yeah.
And then we're gonna need to find out housing.
Back her up. Come on. What? Just have her back. Where she live at? Let's start roping off the area. Let's start roping it off.
Just all units to start roping up the area. Find out the housing. 23, I'll work on housing. Have a unit trying to rope off the area.
You got safe? Yeah.
Unit that can assist roping out the area.
Hey, Chevy, pull my car back. Pull my car back. Pull it back. Pull it back in this open spot for now.
Open it? Yes, I'll open it.
Go ahead.
I'll show you assisting in arrival at 336.
Hey, Get it back to the opening, Chevy. Watch your feet. He's backing up. Go ahead, Chevy.
Show me this one around. Northeast 12 mile right now.
Watch out, LT. He's coming back. Go ahead, Chevy. Go. Okay.
442. You know how 3.
423.
Hey, stop, Chef. Turn your wheel. All the way. You got the tree. Turn the wheel hard this way. This way? Yeah. Back it up. Go ahead. Hey, pull forward. Right there.
All right, get the ropes.
Yeah.
Let's rope it off over here.
In my passenger seat. In my passenger seat. Right there above my headrest, bro. You hear me? Hey, kill my overheads in.
Prior to 19 is going to be a 45. Yes, all prior to 19 is going to be a 45 at 338 on your square. And morning, let's verify your end.
Yes, I'm arrival.
Arrival, 38.
What? Right there above my headrest. Passenger side. Hey, I think he... Hey, we'll start here, I guess, roping this off.
What are you loading this time, right?
I am.
439.
I'm just roping off this whole area, Chef. Yeah, we're gonna probably have to go out to the road.
If we could,
we'll walk back that way. See.
Yeah, just go off over here.
We'll have to put a car on that end, LT. I am.
Do you have any basics?
No, I don't know nothing. She said he left out. He hadn't come home, so she went looking for him. She found him in the alleyway, and she seen that he had the in and out in the thigh, right thigh. I was at 17. I was at 17 and 14, and I heard like a pop, and I started driving this way. But I didn't hear, like it sounded more like a firework. So I started driving down 14, and then that's when they gave me the call. You got more this way? Yeah, we got blood there. LT, you walk. Hey, watch. Chevy, just don't step on it. Yeah.
76, 7.
Tachos on a 2004 Gray Ford to Miami-Dade. Lopez Perez, 2 cages 12.
Yeah, we need to take this off. All this.
Looks like you got out of the passenger.
Somebody must have been driving, bro, if he was in the passenger.
Let's walk off the street.
Hey, give me, hey, somebody got a car?
Hey, 23.
Grab the car. Ma'am, rescue's out with him, ma'am.
423.
423,
Mr. Grant, I see a marked unit. We're gonna need unit in front of the HOA.
Yeah. Yeah, complete blockage of the street. Yeah. Go. Yeah, it wasn't even that long ago, bro. I was at 17 and 14, and I heard a pop, so I started driving down, and then they gave me the call. Yo. What? Hey, bro, I'm gonna use your fence. Appreciate you. Everywhere's crazy.
What's the TPH? They said they found the possible scene.
Verifying at 1289 Northwest 4th Street in the driveway.
2011 reference.
2011
According to the blood trail, he seems to be walking around in circles, so we're blocking off the entire street.
I'll do that for you. You need it more west, or is that fine? No, that's good there.
That's good. Yeah, I'm going to 3 for me.
2011 keep spotted 3.
Try to get his info.
Yeah.
Send a quick email.
Hey, Chevy.
Let's get some rope here too. We need rope here too.
He's got it.
There's the whole front of
Hey, Chevy, you got a whip it on? I don't know, ma'am. He's out with rescue. Give me a second. Hey, can you get her info and then his info from her? Yeah. Please.
Yeah, this rope's gonna have to come all the way through here.
We're just gonna rope. We've roped off the whole road.
No, but I'm saying because these houses right here.
Yeah, so we'll shut down the whole front of them.
Okay.
And then also in the back. Somebody else got tape. Is their car close?
My car's all the way. It's all roped off.
Yeah, rope off this backside for now till we figure out what we got.
I get more rope.
All right. In the alley, where he's at now. Huh? Possibly. I don't know. It's hard to tell. They're getting his info and her info. Hey, man. Why they keep asking? Yeah.
439.
Okay.
You can also 433 if you get a chance.
In the alleyway?
433, are you in the alleyway? Yes, sir. 39.
I'm coming to her. She didn't, fire didn't give us a... Okay. Alright.
He came out of this car.
Okay.
There's blood on the driver's seat. Like if he was sitting on it.
Yo.
More blood right here, bro.
There's
blood everywhere, bro. We're gonna block off this whole alleyway, bro.
Yeah, there's a big puddle right there.
Yeah, he's been all over, bro.
Look. Let's see if we can do call off for day shift and see if we can get some units to come in early.
Here.
We have it here.
Bro, he's been all over. I'm sure if we go back a little bit more. Just doesn't make sense, bro. we're just gonna shut the whole alleyway down.
I'll get it all the way.
Yeah, somebody, whose is this?
That's me, but how do you want to block out these people? They want to come out to the back.
No, they ain't coming out.
QSL, is there anybody on this that we can clear? I believe we should have maybe 5 to hold the scene.
They ain't coming out. It is what it is. It's a homicide investigation.
No, I understand. It's that they're just coming up to the back little cars, like walking.
No.
43, give me a
You're gonna have to have someone in the alleyway.
No, just put the tape on their stuff. We just use their tape. Hey, they didn't give you a blanket for this guy? Fire didn't leave a blanket?
They have stuff.
Let me see if I got one in my car.
You can show me a knife and I'll be in route.
We have a jury question. Is that what I'm understanding? Saying there's a jury question. Let's get back here. Is there a jury question? We're ready for him. You say there's a jury question. Let's see. Question already. All right, well, let's see. Let's see if there's a jury question. We're ready. If indeed there is a jury question, we'll see. We'll be ready. Yeah, CTV is, we'll be right back. See what's going on over here. All right, well, we'll hang here for a minute or two. Oh, wait. Let's see. Sorry, I'm just babbling. All right, jury has a question according to Juliet Janae. So we'll see. It actually came from Juliet Janae, so we'll see. We'll see what happens. We'll see what happens. It was the chat was replying to her saying the jury has a question. So yeah, and it was a ghost gun. You're right. Yeah, it was a 9mm and it was a ghost gun. So just make sure we're live here. We are live. I guess you keep the verdict clock going, right? Even if with a question you keep the verdict clock going, or do you pause it? Northwest, was Daisy a convicted felon too? I don't think so, or not allowed. I don't know if she was convicted. She was arrested. She was arrested for it, but I don't know what. I don't know. To be quite honest, I don't know. I know she was arrested, but I don't know if she. Keep the clock running. All right, keep the clock running. I don't know if she was like. I don't know what happened with that. I know they both were arrested for DV. I don't know what came of it. So keep it going. All right, keep the clock going. Yep, keep it going. All right, no breaks for the clock. Okay. Good. Okay, thanks. Thank you guys. As always, our chat is so well informed. Now I think we're a few seconds. We shouldn't be, but I think we're a few seconds behind. I don't know why, because I was comparing. Remember when I was doing my directorial back and forth? So I think we're a few seconds behind, which is weird. I don't know why. Oh, he's doing defense. Okay. All right, we're good. We're good. Merengia says pause. Not gone on the record with the question yet. Yeah, I'm watching that feed as well. They're just rerunning the defense. Well, we'll stay here. We'll stay here for a few minutes. We'll stay here for a few minutes. Richard in the kitchen. How is Riker today? She's doing fine. Yeah, she's doing. She's resting right now on the chair, and she was playing a little bit. Her limp is like maybe 2% now, 2 or 3%. So she's doing a lot better. So thank you. So let's see. There was a question, but it's not gone on the record. All right. So that means we're not going to. They're not going to. All right. Jury is told to continue to deliberate when submitting questions. Clock stays going. All right. All right, so I guess, should we go back to, I guess we could go back to, still trying to find, well, I guess we could go back to, doesn't seem like, we could go back to the body cam then. Let's go back to the body cam. We'll come back to the body cam. And if you see any movement in that bottom right, we'll blow it up again.
No weapon. 454. He's up. 347.
Apparently he just walked around the house. Bro, he didn't just walk around the house, bro. He walked all over there. Yeah, there's blood all around the corner. Bro, there's blood everywhere. Blood in the truck, though. There's blood in the SUV. Oh, there's an SUV over here? Yeah. Is rescue out there? Can you get their info?
walking back and forth for the last several hours. At one point, she said last time she saw him was like 45 minutes ago, he was walking in circles all over the street. She said earlier today he left in a white van. I know make a model, I don't know if it's a passenger van or a work van. She said it was a white van with a couple of his friends. When he got back, he seen agitated. That's when he started walking around in circles, walking all over the place. And then she hadn't seen him for about 45 minutes, so she started driving around. That's when she found him back. That's all his info there? Yeah.
All right, so that's I still didn't quite get where it started to where he ended up. So they're saying, oh, he's running all around, and that is true. That they did say that, and him running around. I think I said this the other day doesn't help. I mean, obviously his heart's pumping. He was doing a lot of partying that night, so his heart's pumping. Running around doesn't help. His heart, again, your heart's pumping. It's, not that if he sat still and had compressions on that he would have survived 100%. Who knows? Yeah, so that's the body cam. I was hoping to try and find where, because she's saying he was running to the house, to the door, and the defense is saying, Mr. Tomas is saying, well, that's where the blood started. That's the only part where I would be like, I think that's the only thing. Now, let me go back to his, here, we can do this. Put our thumbnail up. Nope, don't want to do that. We'll just blow that up real quick. Sorry, guys. Just in case they come back while I'm talking. All right, defense closing. So the blood trail starts at the front door and goes away. And reasonable fear of passing away or great bodily harm is someone is unlawfully entering a residence. So by that standard, if the blood trail starts at the front door and goes away, that would be the only thing that would give me pause. Yeah, he got shot, from in the back, from the, So I'm like, well, you had meaning the person who pulled the trigger, you had the weapon, you had the, it's on your shoulders to stop, right? To not continue that. But if he's running to the front house, kids are inside, but then you guys brought it up in chat, then she shot towards the house. And it's not like she said she didn't shoot, directly at him. She was just like, just trying to scare him. So what if that bullet, you're right, what if that bullet didn't hit him, went into the house and hit one of her kids? So there's that. Then there's also, okay, so that kind of gives me a little bit of pause, but I could definitely work my way through that. But then the other thing again, for her defense, I'd be like, well, why did you go to the hospital? If you went to the hospital, where is that witness? Where are those pictures? Where are those records? And then also, when Pedro shot at you, where did that bullet go? Did that bullet just go? Where did that bullet go? Because he just shot at her. Where did that bullet go? Did it go in the door, the hall, the wall, the window? Like, these people are just shooting guns like left and right. So where are these bullets going? Well, we know we're the one that Daisy shot at Pedro went into him, but the one that Pedro shot at her, where did that go? So any one of these could have gone out and hit a little kid. What if a little kid was riding a bike or outside playing? Or what if when she shot, she did miss him and it did go in and hit one of her little kids, right? Let's see. Gen XR Meg. I felt so horrible for the kids yesterday. The kids have endured a lot. Broke my heart to have him testify. I know. Let's see. I wanted to pull this up. Sharon, where's the firearm? Did they show it? Did they ever show it? God, I can't remember. I don't know if they ever showed it. I don't think they showed it. It was a ghost gun. I don't think they showed it. All these gunshots, but neighbors don't hear a call. Apparently, yes, when he shot at her, she said, wait, hold on. Yes, when he shot at her, when Pedro shot at Daisy, she got the kids, went with her cousin David. They were going to go to a hotel. She remembered she forgot her phone or something, so she had to go back to the house, and that's when there was a bunch of law enforcement. So she said apparently somebody called. So yeah, apparently somebody called. She had a ghost. She did. And they did show it. Did you guys say somebody showed it? They did show it. I'm trying to remember if they showed it or not. Sherry, yeah, they did show it. I remember it was a 9mm and it was a Glock. I don't remember. God, I don't remember if they showed it. Oh, sadly, all these trials are starting to run together. I remember in the Leslie Boileau, they had that, like, right? Didn't they show that? It was like on a placard, if you will, and it was all zip tied and everything. I do remember that. Yeah, Dwayne, she said, what happened? Right? All right. It looked like a Glock, yeah. And he was unarmed. He was definitely unarmed. Neighbor, police report, cops, yeah. Right? You would think. Where's the dispatch logs? There's so much the defense could have brought in. There's so much that the defense could have brought in that they did not. They do run together a bit. Well, especially when we're doing, like we did Bianca, obviously. Now we're doing Daisy. When we do multiple trials in 1 week, and then when it's like Thursday and it feels like it's Tuesday of next week, I feel like I missed a weekend. Things do tend to run together. All right, let me. What do you guys want to hear next? Do you want to hear openings? I kind of want to hear openings, or do you want to hear her? Do you want to hear her again? What do you guys want to hear? Pick a testimony. What do you guys want to hear? We got Kevin Bonilla. Remember him? We got the sergeant. We saw his body cam. We could listen to him again. We got the firefighter, the first responders. We got the detective. Sorry, we got the firearm expert. I guess that's when they're going to show it. We got the ME. ME was kind of fun. I mean, sad, of course, but his personality was kind of fun. What do you guys want to hear? Her testimony, video in parking lot, her testimony. Yep, defense said only fired to scare him. You want to hear her testimony? All right. Listen to her lies again. All right, let me get to her. I mean, we may have time. I mean, we could definitely listen to a couple. So not her, Emmy. Well, we have three for her testimony so far. We have 3 for her testimony. Let's see. The Ring first. The Ring. Oh, you want to watch The Ring again? All right. You want to watch the Ring footage again? All right. We could watch that. I'm okay with that. Let's show that again. And then we can get to her. All right. Let's see, medical examiner. Yes, her son did take the stand. We didn't see him. All right, her. It's kind of a toss-up between the ME and her. Maybe we'll go with the ME. Well, let's do the ring first. Let's do the ring camera first. I'm okay with doing. Let's do the ring camera first, and then we'll go to. We'll do the ME. I'm okay doing. We'll do the ME, and then we'll do her. How's that sound? We can do the ME, and then we can do her, and we may be able to show it again too. All right, hold on. So right here is when he comes running out. So you just heard the gunshot. Look to the very far right. See the white truck? See all the cars parked? The very far right? That's him. So he was just, we just heard the gunshot and then he goes running. So look to the far right. All right, look to the far right. Yeah, the jury question was not on, it wasn't on the record. Gen XR, the jury question was not on the record. So if you look to the very, very far right, he's just running out right now. He just got shot. He's running out right now. I'll go ahead and I'll rewind it. So now you know where to look. All right, so they're kind of yelling, arguing. He's like, I do everything, I do everything for you, or I do everything, you've got everything, something like that. Then, a couple seconds go by, or maybe half a minute or whatever. And then you hear the gunshot, and then he runs out by those trucks. And then that's when she's like, you'll be fine. Not like I hit a major artery or something to that effect. So where was he exactly when she shot him? That's the question, Lynn. That is the question. That's the question. She says that he was running to the house. The state says he was running away from the house. So that's the question. That's the question I have. Where did the blood initiate? Defense is saying it initiated at the front of the house, by the front door. That's what the defense is saying. All right, so yeah, we'll do the ME first. We can do the ME first. Let me pull this up. And then we'll have time to get to her, I think. We'll have time to get to her. Here, hold on. Okay.
Your Honor, it's prepared.
Judge List.
There's a stipulation I'm going to read to you. There is a stipulation between the parties that the body autopsy under medical examiner case number 2022-1959 is the body of Pedro Jimenez. In other words, the legal identity of Pedro Jimenez has been established by stipulation of the parties. You can start questioning Dr. Mathis.
Yes, Judge. Good morning. Can you please state your name for the record?
Good morning. I'm Dr. Benjamin Mathis.
Mr. Mathis, what do you do for a living?
I am the Chief Medical Examiner of the Miami-Dade County Medical Examiner Department.
And how long have you been the Chief Medical Examiner?
10 days. Last week, they promoted me to Chief Medical Examiner. I've been Deputy Chief for the prior 3 years.
Congratulations.
Thank you.
So you mentioned you've been Deputy Chief for 13 years.
I've been at the Medical Examiner Department for 13 years. The last 3 were Deputy Chiefs.
And can you tell the jury a little bit about your education and training in forensic pathology?
Sure. I went to Brown University in Providence, Rhode Island for my undergraduate degree in Classics Latin. And then I stayed at Brown for medical school where I graduated with a Doctor of Medicine degree. Then I went to the University of Pennsylvania in Philadelphia for my residency in pathology, anatomic pathology and clinical pathology. After completing the residency, I came to Miami for a fellowship to subspecialize in the subspecialty of forensic pathology.
And are you board certified in forensic pathology?
I am.
About how many autopsies, Dr. Mathis, have you performed over your career?
Around 2,000.
And have you previously come to court to testify as to the cause of death of an individual?
Yes.
About how many times have you done that?
Several dozen times. I usually come about 10 times a year. 10 times a year times the 12 years, 13 years I've been here.
And were you qualified as an expert on each of those occasions that you came to testify?
I have.
In what field were you qualified as an expert?
Forensic pathology.
Now, Dr. Mathis, can you tell the jury what exactly a medical examiner does?
Sure. A medical examiner is a forensic pathologist who works for for the government generally. And we're charged with investigating deaths of individuals who died either under circumstances or because of who they are that the state has an interest in. So all non-natural deaths will go to a medical examiner, accidents, suicides, potential homicides, drug overdoses, inmates from the prison, those who die in police custody. And then when we investigate their deaths, we need to determine the cause of death, what caused them to die, and the manner of death, which is how we classify their death. We'll perform whatever investigations or studies we need to do, whether it's a record review, looking at their medical records, to performing a full autopsy, performing special dissections, having special tests run, studies done, also that we can determine what the cause and manner of death is.
And were you working as a medical examiner for Miami-Dade County on June 25th, 2022?
I was.
Are you the original medical examiner who did the actual autopsy on the victim, Pedro Jimenez?
Yes.
So I want to talk about your involvement in this case, Dr. Mathis. When did you perform that autopsy?
June 26, 2022.
Where did you perform it?
At our office. It's a medical examiner department. It's right across the street from Ryder Trauma at Jackson Medical Center next to Miami-Dade College Health Campus.
And when the body arrived for autopsy, what was its general condition?
He was in a fresh state. He had soiling from blood staining on his legs.
And did you observe any signs of medical intervention, such as bandages, anything like that on the body?
Yes, he had a tourniquet on his right thigh.
Now, can you walk us through the steps you take when performing an autopsy, Dr. Mathis?
Sure. So first, we capture the height and weight. We take a receiving photo of the individual. Then, if it's a suspected homicide, we'll get pictures of the hands. Then we'll collect fingernail clippings as evidence. The body will then be washed. We'll take photographs, overall photographs of the individual, and then if there are any tattoos or injuries, we'll take photographs of those. Once the photographs have been taken, then the doctor will take any written notes about the external appearances of the body, of the tattoos, of the injuries, and then at that point, an internal examination, or what people colloquially call the autopsy, will begin to be performed.
So you mentioned a lot of steps there.
Yes.
So I want to break that down. Can you explain to the members of the jury what an external exam is?
Sure. So external exam sounds just like that. We're taking note of the external features of the body. First is the routine. Their body size, their body habits, their height, their weight, their eye color, their hair color.
That Mr. Bavita, you referenced in your closing as a demonstrative. You've printed out those photographs. Mr. Tomas has them now.
And Judge,
Hold on. And then Marilise, I'm going to have those 5 as a composite for now. Mr. Tomas, I'm going to give them back to you. Let the clerk mark them as a composite.
Before we do that, I need to swap out a photograph.
So there's 5 right now, but one of them's a duplicate?
Correct.
You only want me to mark it, right?
Just mark it for now.
2G.
So the substance of the photographs that the state referenced in their closing are the outside of Miss Daisy's home, which encompasses a duplex. There is a 5th one that, Mr. Tomas, you found in your discovery.
Yes, ma'am.
And what does that one show?
So that one shows inside, shows the home, shows the door, I believe it's the back door, and very close to the back door there's a window that you can tell it's in place of glass, there are other things there.
Cardboard.
And this would, I think this would go towards a specific question the jury asked about, I think they were alluding to the testimony that Pedro stuck his hand through the window to unlock the door.
Because at one point during the state's closing, some reference was made about how tall he was, and Mr. Brigida is not as tall as him. Something along those lines. If you remember it better than me, let me know. But something along the lines of reaching in, and how nothing of the outside. The inference was nothing on the outside was damaged. That from where I was sitting, that was the gist of the state's closing argument on that point.
Yeah, I recall, I guess the impression that I got was that this that I'm showing you shows that he couldn't have reached in and opened the door.
I got the same impression. But those photographs that were used as a demonstrative aid are not in evidence.
Well, so yes and no. When I was creating this presentation yesterday, I had a good faith basis to believe that at least some, if not all, of these photos are in evidence. I obviously do not have access to evidence once we are done for the day. I have reason to believe, based off of the testimony, as well as the introduction, as well as conversations I've had with co-counsels, that those photographs were introduced. The other photograph, it's 100% my fault. I missed it. Mr. Tomas brought it to my attention when we were outside of the hall, I believe. I would not have made the argument that I had made. I would have changed it a little bit. It would have been something similar, but I still would have made the same argument. But I still have reason to believe those four should be.
So just print out the duplicate one. Are you going to go get it for us, Mr. Aftala?
Yes, Your Honor. I'll go to the back. Or no, actually I have to go across the street and go and grab it.
Can you make your way over there now?
Yes, Your Honor.
Thank you. So how else do I fix this?
I don't believe it's fundamental error, Your Honor. I understand your concern. I genuinely do. And I lean conservative when it comes to... No, I'm sorry. I lean very conservative when it comes to those kinds of things. It wasn't a predominant feature of my closing.
It was the first question that the jury... They're in there for maybe 10 or 15 minutes, and that was the first question that they had for us.
I understand. If the court wants to send an instruction back...
Why don't I... Do you have any other suggestions?
I think by agreement we can send in those photos, but I don't know what else the court had in mind.
By agreement, you referenced the tattoo of Daisy on his arm. That was part of the autopsy. That photo may not have been part of the evidence. By agreement of the parties, we agreed, because it was referenced in the autopsy, it went back as stipulation. That was number 30 what? 31. This is a little different. It's one thing for them to be in a 9-year relationship. They've got 2 kids. They love each other. There's ups and downs. Him having Daisy on his arm, that corroborates parts of the state's case, doesn't go to the core of either the elements of the crime or the defense to the crime. This does, because it goes to credibility of witnesses. Why shouldn't I bring this jury out and allow Mr. Tomas a minute to explain to them his version of that photograph?
That's fine.
So the only issue is with that, and genuinely, I understand the court's concerns. I have the same concerns. Had I known that this photograph with the back door existed, and it's 100% my screw up, I am completely at fault.
Listen, I take you at your word.
I missed this. I would have still used this photograph, and I would have explained the same exact thing. I don't have an issue with Mr. Tomas being able to explain his version of events.
What would you have explained?
I would have said the window is still far from the door, and that this window appears like it was fixed, and if all of this was going on in the middle of the night, do we really think that this got fixed between the time and the shooting? That's what the argument I would have made.
But your argument is premised upon what you remember of these witnesses saying he stuck his hand through the door that day. I don't remember that specifically.
No, I believe the defendant's mother said that happened that night in between her being choked, or not the defendant's mother being choked, but the defendant being choked.
I don't remember. What do you remember? Why don't you confer with your client also? The other exhibit was also by room of the parties, 31, and this one would be 32, right? Okay. I just want to make sure with my clerk, what we sent with the autopsy photos is 31. That was by room of the parties, and this would be 32. All right. Yes, Mr.
So,
Balash.
Judge, two things. It's hard for me to remember exactly when, but I believe that at some point, Ms. Link, during the testimony, she referenced that she noticed things were missing, and that she had reason to believe that Mr. Jimenez somehow got in through an opening in the window. But her mother did testify that she saw him reaching in through the window, and that would have been the day, afternoon, evening prior to the early morning shoot. So that was my recollection of the testimony.
You know what? I screwed up. I would take the fault of it. I will let the court make the decision and just take it on the chin.
Okay. So if I'm gonna let you talk to the jury for about a minute, what would you say? And I will instruct them that these are the photographs that the court believes they're referencing in their question. They were used as demonstratives, but they are now being admitted by agreement of the parties. And actually, Marilise, yours will be separate.
Okay.
So the 4 for the state will be 32. Yours will be, can it be 33? State's 33? It'll be state's 33.
Mr. Arcall is bringing the last photograph.
Yes, a state as well.
I'm sorry, yeah. The one of the inside is going to be 33. Can you separate it? Yeah, that one's going to be 33. I'm sorry, what would you argue?
I would just say, so ladies and gentlemen, this is a photo from the inside of the home, and as you can see, the door, the window next to the door, it's visibly within arm's reach, and as you can see, the glass is kind of replaced with other items kind of in place of the glass, and this is where Mr. Jimenez would have been able to reach through to unlock the door from the inside, from the outside.
Okay.
And that's it.
Are you in agreement with that? Okay, because it wasn't, I think you can appreciate, Ms. Link, these photos that the state referenced in closing weren't introduced into evidence, but they were on the television. And I think that's what the jury is asking about. That was their first question. In order to remedy this, which is error, I don't know if it's fundamental error, but it's error. I think it's fair for me to allow your lawyer to introduce the one of the inside of the house that has cardboard with Modelo taped or appears to be taped on the window, and for him to at least address the jury about a minute to make his argument to rebut the photographs of the outside that the state argued showed no damage. Does that make sense?
Yes, ma'am.
Okay. So.
I'm just waiting to start.
Yeah, that's fine. So we can go off record while we wait. So the 4 photographs of the outside of the home that were referenced as a demonstrative are composite 32, and the one on the inside with the cardboard that shows potential damage is 33. So we can go off record while we wait for Mr. Octala to come back so we could staple it to the to 32. Thanks, Stephanie.
Sadly, this is at least the third time that the state has screwed up, if you will, or something has been not proper. This is the third time. So basically, the state showed something on the TV, and then the jury is asking to see photos of that window that Pedro allegedly broke through to reach through to open up the door, to unlock the door. So the jury's asking for a specific photo that they saw on the TV, but the state didn't introduce that into evidence. So they brought it up during their closing. So the state brought this up during the closing. He's at his TV doing his demonstrative, and it was there. But now the jury is back, and they're like, where's that photo? That photo doesn't exist because he didn't introduce that into evidence. So this is the third time Now, this was in front of the jury. The other 2 times were not. The other 2 times he brought it before the jury came in. He said, I just want to make sure that this isn't prosecutorial misconduct or, a violation. Oh, sure, just show the jury room. Let's just watch the jury come in. So the other 2 times, to be fair, on his side, he's saying, hey, I just want to make sure everything's square. I didn't do anything wrong, blah, blah, blah. And judge ruled, okay, no violations, nothing, no harm, no foul.
You can go ahead and hold on to them.
Yes,
Meredith, you can give that to Mr. Jones. All right, folks, we're back. Thank you. So 1, 2, 3, 4, 5, 6. All jurors are present, lawyers as well as Ms. Link. Okay. In order to best answer what I think you were asking, the lawyers also think the same regarding your first question. There are 4 photographs that the state referenced in their closing. Those were demonstratives, so they were not in evidence. By agreement of the parties, they are now introduced into evidence. 4 photographs, 1 composite, number 32. It'll be a state exhibit. In fairness to the defense, because those items were not introduced into evidence, I'm allowing states 33 in Mr. Tomas's hand, and he'll be able to address you for about a minute as a rebuttal to what was not introduced into evidence, okay? Go ahead, Mr. Tomas.
So, ladies and gentlemen, this is a photo for your consideration. This is Exhibit 33. As you can see in this photo, here is the door, photo from the inside of the house. This door is in close proximity to this window. And as you can see, this window has items taped which are taking the place of the glass. So instead of having glass, this window is really covered up by these, cardboard items, and you can see that they're taped together. So this is being submitted to you because, as you can see, Mr. Jimenez could have feasibly, from the outside of the house, stuck his hand in through this open window next to the door and unlocked it and opened it from the outside. So I believe this was relevant for your consideration. It's Exhibit 33. It's going to go back with you, and you can look at it as much.
We'll hand it to you now. 32 and 33. We'll hand them to you now, and you can continue your deliberations. Thank you.
Thank you.
They've now gone back in. I'll be upstairs. We can go off record if anybody.
Before we do that, I just want to apologize again. It's entirely my fault. I did not. I missed it. I just want to put it on the record. It's entirely on me. And I
understood.
It's an honest mistake. We all make mistakes.
And I think we remedied it, and by allowing you, Mr. Tomas, to directly address the jury and point out what you wanted to point out, I think it took care of it.
I appreciate it.
We'll see where it goes. Thank you.
All right. Interesting. This trial has been never a dull moment. Never a dull moment with this trial. All right, so basically the state was showing, during their closing, he was showing some demonstratives. He was showing the window and the door, and then it did not go back into evidence. So the jury's like, hey, wait a minute, we saw that during your closing. Where's that evidence? We want to see that. And so the court allowed the defense to rebut that. So now the defense came back and said, well, it's pretty feasible to think that, according to Daisy and her mom, that Pedro reached through the door because it just had some cardboard on, broke through and unlocked, reached around and unlocked the front door. So the state was, apologizing profusely, and the defense said, hey, we all make mistakes, and the judge says, well, it's remedied, and let's get back to it. Whew. Wow. So that came in at around, I guess about the one hour mark. Say 1 hour mark. or around 3:15-ish. We'll say 3:15. Yeah, 3:15-ish. All right. Never a dull moment. Never a dull moment. Do you think, okay, so now my next question to you guys is, do you think that'll make a difference for the jury? Now that the jury's like, hey, wait a minute, this guy was trying to break in? What do you think? So the window was already broken. Yep, the window was already broken. She had some cardboard taped up to it. Do you think that makes a difference? Oh, maybe that's where he shot. When he shot at her, maybe he broke the window. Maybe the bullet went through the window. Right? So Trixie says, oh, so wait, the defense could have objected to this during closing? I don't think they caught it. I guess they didn't catch it because he showed it as a demonstrative and then it never was introduced into evidence. I guess he never really thought much about it. I guess he didn't think much about it. I mean, I guess he just thought, oh, it's a demonstrative and whatever. No difference for you? Yep, makes no difference. Allie, how could that be relevant? I don't know. I'm throwing it out to you guys. Well, I guess if anything, would it show that he's breaking in? He's breaking in. It goes to her theory of he's breaking into her house. He's stealing things. He's breaking in. He doesn't live here. He doesn't have a key. So to me, it would go to her theory that he's breaking in. How would you guys feel if somebody's breaking into your house? You know, again, that just goes to her theory, her state of mind. You know, she's in fear for her life. He's breaking in. This proves that he was breaking in. He doesn't have a key. I would say it would go to her theory of that. So, yeah, Sharon, he says, and when David Perez, her cousin, was there with his 3 kids, they had come over to play with her 2 kids. Pedro came over, found the 2 of them saying, hey, who's this guy? She's like, it's my cousin. Pedro gets upset, gets the gun and shoots at her. After they wrestle for the weapon. So yeah. Bonfire says it will make a difference. Going to get off. She's going to get off. 3-2-1. This trial has been wild. Reminds me of YSL Young Thug. Yeah, I didn't really watch that one, but that one sounded pretty crazy. Jennifer, cardboard already on the window means pre-existing damage. Absolutely. Yeah. So. And Kelsey, yeah. So when he pistol whipped her, he shot at her first. Mary, nice. Maybe, baby. Joanne, isn't the jury told that opening and closings are not evidence? Yeah, and it was being used as a demonstrative. I don't know. I don't remember him doing it in the moment because, you know, the camera angle and all that stuff. So I don't remember. So I don't remember during his closing when that happened. I don't remember. Mary, no difference to me, but why did jury ask for it? Right. And he would have broken the cardboard, of course. Yep. Prosecutor, Acme School of Law. Yeah, he's had some slip-ups. David did not testify. Not breaking in that night. No, this was the 5 days before when he pistol whipped her. So this was. Wait, hold on a sec. Because was that when David was there? Hold on. Because Mom testified to it, so Mom wasn't there. Hold on. Let me see who did testify that. Hold on. Okay, she was outside with Daisy. Pedro stuck his arm in broken window and unlocked the door. That testimony comes from the mom. So David, this was the night of. Right? He went inside, started knocking over items. Daisy shouts for him to get out. Pedro doesn't leave. She's at the front window. He's reaching through the broken window on the back door. Daisy says, get out. Pedro grabs a purse. So this was the night of. This is what the mom. So David was not there. David was there the 5 days before with his 3 kids playing with Daisy's kids. And then Pedro comes in. Oh, that's when there's a huge bam, 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 like a knock on the door, like she said, like the police bang on your door. And she lets him in. So then the night of, this does go, I think, to her theory of like the night of, mom was there, Pedro comes in, sticks his arm through a broken window and unlocks the door. So it was the night of. Sharon, I could have a job in court. I just take good notes. Which poll? We have a poll going. You want another poll? Rocky, yes, it was the night of. Yeah, well, I just confirmed it was the night of. According to mom, who has been shown to lie. Then there's that, Mary. Then there's that. Richard, hopefully jury realizes that evidence of old damage and not the night of. Well, according to mom, it was the night of. I'd make an excellent court reporter. Thank you, Widespread. I just like to take notes. Yeah, so it was the night of, according to mom, according to my notes, this was what she said. Daisy and Pedro came back to her house. She observed Pedro choking her. Mom says, I'm going to call police. Pedro, don't call the police or I'll lose my career. And he ran outside. He came back 15 minutes later. She was outside with Daisy. Pedro stuck his arm in a broken window and unlocked the door. He went inside and started knocking over items. Daisy shouts, get out of my house, give my stuff back. Pedro didn't live there. He would show up. She's at the front window. Pedro is reaching through broken window on the back door. Daisy says, get out. Pedro grabs the purse with cell phone. He took the whiskey on the stove and went through the back door. So this was the night of. The third time Pedro was hiding in the alley. Yeah, this was the night of. So that's the night of. Let's see. 321, yes, there was, hold on, let me pull this up. They were lesser included, it was the manslaughter. So she's up for second degree and the lesser included is manslaughter. But with a firearm, I think she can still face up to 30 years. I think Woke, I think you found that for us yesterday. You want me to check RA? Why do I need to check RA? We're live. I'll check RA, but we're live. No, Scott's in some other trial right now. Scott's he's doing a verdict watch. He's in some other trial right now. So, Northwest. Pedro's mom was not even in the state. Well, not the night of. She was there. Right? She was there. That was that. Right? She came to take Daisy back to Texas. So wait, I'm confused by that. Sally, did anyone find the bottle of whiskey outside? No. We are live. We are live. They had a question. They addressed it. And now they're back to deliberating. All right, you guys are confusing me. Mom was there. Mom was there. Mom came from Texas to take her back. You guys are confusing me now because Mom was there. Yeah, mom was there. Next day they were going to have a barbecue. Then she gets a call saying, come get the kids. Why are you guys saying... Yeah, Sue, we got it. We were live here too. We went through the whole thing here. Oh, I said Pedro's mom. No, sorry. Okay, no, that was my mistake. No, Pedro's mom was never a part of this. No, this was always Daisy's mom. Sorry if I confused you guys. No, this was Daisy's mom. This was Daisy's mom. Daisy's mom, not Pedro. Yes, sorry if I misspoke. It's Daisy. Daisy's mom. Correct. All right, so the juror's question was basically, we didn't actually hear the question, but it was, they were confused about the state had presented in their closing arguments a demonstrative of the broken window that had some cardboard on it, and the testimony was that Pedro had reached through the cardboard to reach through and open up the lock the night of. And so then when the jury goes back to deliberate, they want to see that picture, and that picture wasn't there. So they're like, hey, where's this picture? So the state basically owned up to it, said it's entirely my fault, my bad, 100% my fault for having that missing photo. So then the defense was able to rebut that, and they said it's entirely feasible, the closeness of the window to the door, that Pedro reached so corroborating mom's testimony that Pedro reached through this window that was already broken, that had cardboard on it, reached through to unlock the door. So there, that should be, and it was the back door. Yes, it was the back door. Isn't it ball of confusion? Isn't it a ball of confusion? I think, yeah, it's a ball of confusion. This is definitely, whatever it is, this is a ball and or a state of confusion. Dazed and confused, right? Seriously. Let's see. What's up, buddy? Yeah, hi. Mom is lying for the daughter. No, don't step on that. Do not step on that. Hi. Good boy. All right. MLC, the way they were escalating it seemed to me this could have happened to either of them. It's only a matter of when. Yeah, that's kind of like Sarah and George. Kind of like Sarah and George. You know, if George had gotten out of the suitcase, would he have done something to Sarah? Same with Ashley and Doug. You know, Ashley or Doug, who knows? I mean, yeah, these relationships, we run across them often, and it's just a matter of who's going to take out who first. Oh, you're doing Genesis, Land of Confusion? Gotcha. I was going with Ball of Confusion. Good question on the juror's part. Ambi says. Sherry, you heading out? All right, go and water your garden. Very good. Hoping for a verdict today. See you all tomorrow. You did hear a kitty. Yes, that was Fed. That was Roger Federer. Cheddar Federer. He's hanging out. He's licking himself right now, but what's up, buddy? He's just like an instant purr machine. As soon as you even just look at him, he starts to purr. And if you touch him, forget about it. He's just like purr, 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 purr. The window was broken already. Yes, the window was broken and they had cardboard over it. The window was broken and it had cardboard over it, and he reached through the cardboard. So yes, that is correct. That is correct. Well, kickboxing mom. Well, he's over here. He's not far. He's just cleaning himself. Super Ball's over here. Super Ball's over there. Little Feder Cheddar's over here. What's up, buddy? Hi. Yeah. What's Good boy. It's a good boy. Yeah, temptations, yep. Ball of confusion. That's what the world is today. And the band played on. I don't know if you guys can hear him. It's kind of far. It's about a foot away from the mic. I don't know if you can hear him. Rocky says the state was saying in closing that he couldn't reach the locked door to unlock it because it was too far for him to reach. That picture shows that he could and did. The defense proved he could. Perfect. That's perfect. Aw. Joanne, yes. Pedro was a victim of love, Hellwriter says. You're welcome, Kickboxing Mom. They're saying maybe a verdict. All right, well, we're here. Allie B. Riker's feeling much better. Thank you. Thank you. We're ready. She's about 90, I'd say 8%, I would think. I think she's about 98%, so thank you. We're live. We're right here. We're live and ready. We're live and ready. So we are live. Jury has a verdict. Yep, you're right. Court TV saying jury has a verdict. All right. Well, we're not going anywhere. Yep, they stopped their clock at 1:37, so we'll stop our clock as well. We'll stop our clock. So we have a verdict. Verdict is in. Verdict is in. Let me just make sure Scott's got it. Okay, Scott's there too. Good. All right. That's a quick verdict, you guys. I guess we can end our poll. So 3:45 basically. So an hour, 36 minutes roughly. We'll go 50 seconds. Why not? All right. So how long will the jury take? Boy, that was a fast verdict. What do you guys think? Now it's like, okay, wait, we got to get a poll up. What's it going to be? All right, let me get a poll up. Let me get it up. I got to get the poll up. Pull up. Hurry. Quick. Do a poll. What will the verdict be? Sometimes I amuse myself. Not guilty. Guilty of second degree or guilty of manslaughter. All right. Got a poll. We got a poll. Quick. Do a poll. All right. New poll. New poll for you, chat. All right. And CBS is reporting it as well. All right. Well, we're on it. We are live, you guys. We can't get any more live than this. We are live. And we have the feed, so we can't get any more live than this. We cannot get any more live than this. So we'll see. What do you guys think? What do you think the verdict will be? Not guilty, guilty of second degree, or guilty of manslaughter? Yeah, that photo may have done that. Yeah, that maybe that's all. Maybe that's all it took, because that shows, in my opinion, if I'm arguing for the defense, that would to me show that he is basically breaking and entering. That goes to her state of mind of being afraid, of being intimidated, right? If I was arguing for the state, arguing for the defense, I would say that goes to her state of mind. She was afraid. Her kids are in there. He's breaking in. What could he possibly, what else is he going to do? That's what, if I was arguing for the defense, that's what I would. So we'll see. Oh yeah, how long will the jury deliberate today? 38% of you thought 2 to 3 hours. 33% of you thought 3 to 5 hours. 36% of you thought 1 to 2 hours. So 26% of you got it right. 1 to 2 hours. 3% thought 0 to 1 hours. I think I went with 2 to 3. I think I did the 2 to 3. So I went with 2 to 3 myself. Kathy, but she pewed him as he was running away, and she picked him up and brought him there. Yeah, no, and then there's that. That's the argument of the state. Hey, she brought him over. How afraid could she be? And they kept saying that. How afraid are you? You picked him up. You brought him home. How afraid are you? Yeah, and that's that. So that's the struggle. That's the struggle. I think it's going to be manslaughter. I think they probably feel for her because there was evidence of her being, knocked around, but she did do this. So I'm my bet. If I was a betting man, I'd go with. As a matter of fact, that's what I did go with, was manslaughter. I picked manslaughter myself because she does need to be punished. I don't think she gets away scot-free, but she wasn't. There was evidence that he laid hands on her. So that could be an out for the jury, where she does spend some time in jail, but she's not going away for life or for a long time. So yeah, that's where I'm leaning, and I'm thinking manslaughter. Sakari, that's what you picked too. Yeah, I think I don't know. That's where I'm leaning right now. Hellrider, yep, you're agreeing as well. Amber, a quick verdict has got to be guilty. Also, what amount of time is she facing? I think it's because it's with a gun. I think Woke, you looked this up yesterday. Manslaughter, I think it's 15 years, but you add in the gun. Yeah, it's up to 15 years. It's a second-degree felony, punishable up to 15, but add in the gun, it's another maybe 10 or something, but she'll be eligible for parole. So she will be eligible for parole. So manslaughter in Florida is 15 years, up to 15 years, but you throw in a gun and then a firearm, then it becomes more. Becomes elevated. It does become elevated. So maybe it's 25. I think it might be 25 years. Woke, are you still with us? Can you hear us? I think you looked it up and I think it was 25. I think it was 25 years. I think it was 25. If you're still with us. Woke, are you still there? Yeah, so just straight up manslaughter is 15 years, up to 15, but then because it was a firearm, it's going to be, I think it was 25. I think that adds another 10 years, I think. So she'll probably, it's 30? Okay, 30, thanks, Woke. So 30 with the firearm. All right, thank you. Appreciate that. So up to 30, so she might get, well, who knows what, this judge may be, I don't know. We'll see what this judge isn't going to sentence her today. That's for sure. But thank you for that, Woke. Appreciate it. She won't be sentenced today if she's found guilty. They may come back not guilty. They may just come straight up not guilty. I don't know. Who knows? Sharon, it would be the jury. In this case, it's the jury. The jury's going to decide. Melissa, are they back with the verdict? Yes. The verdict is in. Verdict is in. Let me just say that. Verdict is in. Verdict is in. All right. Let me post that as well. The verdict is in. We'll just leave it up there for a little while. Yeah. All right. Just my gut right now. I'm thinking I'm gonna go with manslaughter only because I think that there was enough evidence that Pedro put hands on her, and the jury is probably going to say, well, it was justifiable, and yet she did take his life. He was running away, or she shot him in the back, so we can't let her off completely, but we also have to keep in mind she's got 2 young kids. You know, I'm just thinking these are all the things that I would be talking about. I'd be like, well, she has, 11-year-old, and a 9-year-old. We can't send her away for the rest of her life, even though she did shoot him in the back. But there's evidence that he was aggressive to her. He did lay hands on her. So that might be a compromise. Maybe the jury had a compromise, So my gut is saying manslaughter. I'll go out on the limb. I'll go out on the limb and say they're going to come back with manslaughter. Tasha asks, how far are the trucks from her front door? It looked like they weren't that far. Can't go on feelings of sympathy, of course. No, absolutely not. But there was evidence. There was evidence that he laid hands on her, and he broke through a window. Even though it was cardboard, he still broke through. Here, I can get rid of that. Tasha, it didn't look like it was that far. Maybe 10 feet. Maybe 10 feet.
Lawyers are present as well as Ms. Link. Jury is telling us they have a verdict. I'm going to bring them in. Before we publish, before we publish, listen, the lawyers did a good job. I know there's family members on both sides. We will all keep our calm and composure. I'm not going to say it again. Anyone who disrupts these court proceedings will be immediately removed, number one. Number two, the jury did their job. They will not be felt one way or the other influenced by anyone's reaction. Okay, let's bring him in.
All right.
Alrighty, all jurors are accounted for. We can be seated. Mr. Bowie, you're a foreperson. Yeah.
Yes.
Bowie, you have a verdict. Yes. So I'm going to review it just to make sure everything's been checked off appropriately. After, if it's all in order, the clerk will ask you each one if this is your verdict, and then we'll take it from there, okay? Okay. All right, Ms. Link. The State of Florida versus Daisy Link, case number F2211523. Verdict, we the jury in Miami-Dade County, Florida, find the defendant, Daisy Link, as to count 1, second-degree murder, guilty of second-degree murder. If you find the defendant guilty of second-degree murder, you must answer each of the following questions. Number 1, did the defendant actually possess a firearm during the commission of the crime? Yes. Number 2, did the defendant discharge a firearm during the commission of the crime? Yes. 3, did the defendant discharge a firearm causing death during the commission of the crime? Yes. So say we all, the 16th day of October 2025, signed by the foreperson. All right, Marilise, we're going to poll the jury.
The jury, if you heard the judge read the verdict, as I call your name, if this is your verdict, please answer yes. If this is not your verdict, please answer no. Keenan Bowie?
Yes.
Ramona Espinosa? Jacqueline Smith?
Yes.
Tiara Campo?
Yes.
Esther Montoro?
Yes.
Lawrence Vega?
Yes.
Judge, the jurors have seated.
Okay. I just have one more thing I have to read to you all. Let me just pull it up real quick. It's one paragraph long. Ladies and gentlemen of the jury, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. And with that, I thank you again. Please go outside with Umberto. I have a certificate of appreciation for you. I'll shake your hand. We'll give you back your electronic devices.
So before you do that, can I come step up and I apologize?
Sure.
All right. So that's it. So I heard, okay, so guilty, second degree, possession of firearm, discharge of firearm that caused Pedro to pass away. 145 votes. What will the verdict be? 44%.
Now we can all rise and you all can go outside with Umberto.
No, following you.
All right, folks, we can go off record for 2 minutes. I'll be right back.
All right, so second degree is maximum sentence of life, but mandatory is 10 years for those with a clean record. However, if a firearm is used, mandatory minimum increases to 25, which can potentially lead to lifetime sentences. So I don't, Sharon, I don't think the jury is going to decide. I think this is a judge. This should be a judge sentencing. And hold on, let me close this. This will be a judge is going to impose the sentencing. Probably not today because they have to do impact statements and all that stuff. But second degree conviction carries maximum of life, but a mandatory minimum of 10 years with a clean record. But if a firearm is used, then the mandatory minimum increases to 25 years. So she's looking at 25 to life, it seems like. And then I was listening to, so the male, the foreperson was male, and then when they said, is this your true and accurate verdict, I heard 3 females, 2 males, and there was one in there, the second one I couldn't quite, and they let go 3 women too, don't forget. So it was a panel of 9, and there was at least six women.
We're back on record. Lawyers are present, as well as Ms. Link. All right, Ms. Link, the jury's found you guilty. I will adjudicate you guilty. I'm inclined to defer sentencing for another day.
The defendant is not a convicted felon. She has such holds. Would otherwise be held as PSI. I don't know if the defense is waiving that or not, but I would, if we already got a sentencing, other than the waiving of PSI, it would need to be referred.
Do you want me to order a pre-sentence investigation?
Yes, please.
Okay. All right, so we'll order a pre-sentence investigation. They usually take about 8 weeks, so we'll just reset this for about 8 weeks' time. It's going to print tomorrow anyway, Mr. Tomas, because we're after a cutoff date for the clerk of court. 8 weeks from now puts us roughly around Thanksgiving. So I'll just ask for the pre-sentence investigation to come back the Friday before Thanksgiving, the 21st. Is that all right?
That's fine, I can make myself available.
That's just for the return of the PSI. It's not for actual sentencing itself.
Yeah, that's fine.
Okay, so 21st is the next court date for the return of the pre-sentence investigation. If it's back then, we can pick a day for sentencing after we get the pre-sentence investigation. Is there anything that I need to address from the parties before we adjourn for the day?
I don't believe so.
All right. Thank you all. We're adjourned. I can sign it tomorrow. Okay. Umberto.
So it's really interesting. Yesterday, when they found Bianca Ellis guilty, they handcuffed her immediately. Do you guys remember that? I mean, they handcuffed her as soon as they said guilty. She was handcuffed. It's really interesting. Different jurisdictions, different states. Same with Todd Mullis. As soon as they said guilty, boom, he was handcuffed. Bianca Ellis, boom, she's handcuffed. Now, it seems like they're fingerprinting her. Maybe they're fingerprinting her? Yeah, I think they're fingerprinting her. So, yeah, they're not, it's really weird, right? They're not handcuffing her. They're just letting her hang out. Yeah, differences even between judges in the same circuit, Crunchy says. Yeah, I remember Sarah Boone, she got fingerprinted. But I think Sarah was still in the chains though. I think Daisy's just like all free and clear and all willy-nilly. Is there like anybody around her? Could she just like take off? Could she just like bust out? Is Daisy gonna like make a run for the? Oh, that must be. I guess that's her. It's her family, I guess, or maybe that's Pedro. That could have been Pedro's family. Could have been Pedro's family, because we know what her family looks like. Could have been okay, there she goes. Yeah, she's not even handcuffed. Is she handcuffed? Okay, I guess she's handcuffed. Wow. Interesting. All right. So ends another, wow. I was going to say, so ends another trial, and that's two verdicts in 1 week. We did 4 verdicts a couple weeks ago. We did 4 verdicts a couple weeks ago, and now we did 2 this week. So, I'm going to stay here for a minute or two. I don't think they're going to do a press conference, but you never know. You never know if there's going to be a presser or not. All right, they just ended. So they ended the feed, so that'll be it. That'll be it then. All right. We can answer some of your questions. Nanar, you just woke up. Well, we have a verdict. I won't spoil it if you want to go back and look at it. CCG said, yeah, maybe she had him like, did she have the waist, right? Was it around her waist? Could have been around her waist and then, tied, in their front. Amber, maybe she had an ankle cuff. Maybe. Yeah, she is cuffed. Sharon, golly, Wally doodle, what a day. Right? Amber, I'm actually surprised by this verdict. Nomad, have a wonderful rest of your day as well. Thank you. Sparkling Princess, thank you. Thank you for hanging with us. Marintia. Thank you. Enjoyed watching the trial with you. Appreciate that. Dwayne, I know what joke about her running you're going to make because I said the same thing. Right? Yeah, I didn't see him put her on. Maybe when the camera kind of zoomed, the camera kind of went back to the gallery. Maybe that's when they put him on. I don't know. Not yet, Valerie. She will be sentenced after Thanksgiving because they're going to do a PSI, which is a pre-sentencing investigation report. It's going to be back no later than the 21st. She said it normally takes about 8 weeks. And then this PSI, pre-sentence investigation, means they put together a report of the mitigating factors, the aggravating factors, which basically just means the pros and cons. Does she deserve to go maximum, or does she deserve to have some leniency? So both sides get to argue and write down, and the judge has a scorecard, and she goes through the scorecard. So, all right, Hell Rider, have a good one. Oh yeah, it's your Friday night, right? Thursday's your Friday. Be good. Have a good one. I don't know what we're going to do tomorrow, you guys. Maybe we'll do an ego. We'll do an ego takes the stand. Maybe we could do an ego. Because tomorrow's Friday, right? Today is Thursday. We could do an ego takes the stand. Yeah. Thanksgiving is usually the last Thursday of November. So this year, Thanksgiving is the 27th. So she wants it back the Friday before, which is the 21st. So Thanksgiving is the 27th. Usually nothing gets done that week either. Maybe Monday, but Tuesday, and certainly by Wednesday, everybody's kind of shutting down, at least, the non-essential workers. So Thanksgiving in the U.S. is the 27th of November. Judge wants the PSI back by the 21st, which is the Friday. And then they'll set sentencing after that, which will probably be in November. So we probably won't get a sentencing for her until November. Yes, Sweet Vampy, guilty, second of the highest charge, second degree, and then possessing firearm, discharging firearm, and that firearm caused Pedro to pass away. Widespread panic, ego sounds good. Yep. Missy, I like the ego, right? Allie, can you explain what the PSI does or doesn't do? It's pre-sentence investigation, and let me see. Did I already explain it? It's a pre-sentence investigation report. It's for mitigating and aggravating factors, basically pros and cons, and it's a chance for both sides to argue, hey, Daisy shouldn't go away for life because X, Y, Z, and then the state says Daisy should go away for life because of X, Y, Z. So that's pretty much what it is. Oh, let's see. Yeah, Kathy, this was an emotionally exhausting week. I hear you. We're going to go work on, Aaron's been working on this Halloween video. You guys are going to die when you see this. This is like, Aaron blew it out of the water with this Halloween video. You guys are going to really, you're going to have some fun. Suma, your cats with the fluffiest tails. Oh, cats have the fluffiest tails. Yeah, Mama, you should see Mom. Polly's got hugely fluffy tail. Just let me see. There's a little. I think that's Riker. Riker, what are you doing? Here, let's get Riker up here. She's the one that fell out of the live oak right back there, like 25 feet. Come here, kiddo. Come here. Oh, come here. Oh, that's my good girl. Here you go. That's my good girl. Say hello to the people. Say hello to the good people. Say hello to the good people of Earth. The little alien comes in peace. Do you come in peace? Go say hello. Yeah. Hi. Good girl. She's such a sweet little girl. My little alien. All right, I gotta shut that curtain. Sorry, kiddo. That's right in my eyes. Let me pull this over. All right, and we got Super Ball over here. Super Ball's right here. Super Ball's getting some sun. Big marshmallow that she is. All right, let's see. Okay, yeah, so Halloween party, we're going to do a stream on Halloween, obviously. Probably around 8 o'clock Eastern. And we're going to be starting the game, I believe, on Monday. I think we're going to do it on Monday now because we may drop it tomorrow. I'm not quite sure, but it's going to be at least the 2 weeks before Halloween. And we are going to invite you guys. It's going to be interactive, and we're going to invite you guys to participate. So I hope you guys are looking forward to that. I know I am. And definitely mark your calendars for Halloween night, which is a Friday night. If you can join us, that'd be a blast. We're gonna have some special guests on too, so it's gonna be a lot of fun. So let's see. So tomorrow's Friday. Yeah, maybe we'll do. I want to do Chandler Halderson, but he's like a 7-day trial, 7 or 8 day trial. Also Anthony Tote, we were going to do him, but I like Chandler because we did him last year around Halloween. I had no idea what his trial was about, but as I look back on it, I'm like, wow, he was sadly like perfect for Halloween because he took out his parents, he tried to burn them in the fireplace, he dismembered them. I mean, it was just really gruesome and sadly very appropriate for Halloween. Here's Super Bowl. What's up, kid? What's up, kiddo? Yeah, it's a good girl. All right. So maybe an ego takes the stand, but we've got nothing next week. The 27th, though, Sunny Bell and Bianca Ellis, both sentencing. Excuse me, for the Sunny Bell 5, the Florida 5, those guys, and then Bianca Ellis are on the 27th. But next week is wide open. So we either find a new trial or we're going to do Chazzy Boy. So maybe Chandler. We might do Chazzy Boy. So Dwayne, yes. Dwayne loves his Super Bowl. Kathy Smith, yes. Amber. Hi, Super Bowl. Everybody saying hello. Bluebird, yeah, you watched that trial. It was crazy. It involved others. All right. Chandler, another massive liar, 100%. Yeah, and remember his girlfriend, Kat? He brings his girlfriend, Kat, over, and she's like, what are you cooking? And he was like barbecuing something, and I'm like, oh, I couldn't help but to think that he was cooking up his parents. Green Eyed Cat, that was a case for all time. Terrence Crosby trial from Boston. All right. Sally says, Barry, we always find trials by surprise that turn out to be important. That's true. That's absolutely true. I had no idea what this trial of Daisy Link was going to be about. And often what happens is like Sunday night, we'll like look at, the major feeds and we'll go through and we'll say, oh, they're starting a trial on Monday. Or a trial is starting on Tuesday. So we'll do some research. We'll always come up with something fun for you guys to watch. And if not, we have Chandler. We have Chandler as a fallback. Super Bowl. Trying to get this mic out of it. All right, there. There's Super Bowl. We always have Chandler as a fallback if there's not a new trial starting. And if there's not a new trial starting, we have Chandler as a fallback. So, all right, you guys. With that, I'm going to say goodbye. Class dismissed. Thank you so much for joining us. Really appreciate you spending time with us. I know you guys have a choice of where to watch your trials, and really appreciate you hanging out with us, and Super Bowl, and Riker, and Paulie. Although Paulie's not here. Fed's not here. And of course Houdini and Rafa. All of our wonderful cats. So thank you for hanging out with us. Really appreciate that. I'm trying to get Super Bowl to look up. Hey, what's up here? Oh, that's a good girl. Yes, a good girl. That's like, she's like Jaws coming at you. Hey, what's here? Yeah, it's a good girl. She's a big marshmallow. All right. Again, thank you for joining us. Thank you to our mods. And she's attacking my mic. Thank you to our mods, and thank you to Erin. Again, she's putting together this Halloween video intro that you guys, I think, are going to be really, really going to be blown away when you guys see it. So with that, thanks again for joining us, and we will see you tomorrow. One way or the other, we'll either start Chandra Halderson, or else we'll do an Ego Takes the Stand. But either way, we'll be on tomorrow, probably 9:30ish. We'll probably be shooting for about 9:30 or so. So have a great one, and we will see you then. Oh, you know what? Hold on a sec. Do you guys want to? Is Scott live? Is Scott do? Should we go do a raid on Scott? Is Scott still live? Yeah, why not? You guys want to go do a raid? Let's do a raid on Scott. I don't think we've ever done a raid on Scott. Do you guys want to do? Let's go raid Scott. He raids us so often. Let's go raid him, right? Why not? Let's go do. Don't lick. Let's go do a raid on Scott. Wait, hold on. Let me see if I can do this with Super Ball licking my fingers as I'm trying to do this. Let's see, where's Scott? Okay, come on. Don't screw it up. All right, dude, come on. All right. Let's do a raid on Scott. All right, let's do a raid on Scott. Here we go. Portal enacted. Raid coming. Have a good one, guys. We'll see you tomorrow. Bye.